for delivery of judgment WBC 509 of 2025. Petition is dismissed, being devoid of merit. The interim order, if any, stands vacated. Any mention?
Made, please, your lordships. But I'm mentioning online, my lord, if your lordship permit.
Yes.
Lord, item number 7, my lord. Lord, I have some difficulty today. I was supposed to come, but some urgent matter has come up over here at the principal bench.
Okay.
So can
For
I
the
pray this
petitioner.
matter be taken on?
Yes,
Yes,
for the
on 1st of
respondent,
June. My friend is there. My lord. But he has also some
Where is
urgency,
the
but I know.
When do you want, you said?
1st of June, my lord, for admission, my lord. That
1st
can
of
be
June.
disposed on.
Is it okay?
My lord, there is a urgency. This is the initial stage of investigation, my lord. This petition is for quashing of the FIR.
Lord, I'll demonstrate before your lordships, my lord, that it's a case where, my lord, so far as my client is concerned, there is no.
Mr. R. Dubey, Land Council for the petitioner, submits that he has some personal difficulties today, and therefore pray for listing this matter on 1st June. 1st June?
My lord. Yes, my lord, yes.
Okay. Mr. S.K. Deori, Land Council appearing on behalf of the respondent, has shown some urgency. However, as prayed for Mr. Dubey, that he has some difficulties. The matter stand adjourned to be listed on 1st June. Okay, listed accordingly on 1st June. Okay.
I'm all right.
My lord,
But
if
there
you
is an
continue
interim
mail
order that needs to be continued.
The interim order passed earlier shall continue till the next date of listing. Okay.
Till the next date.
Okay.
Yes, ma'am. I'm so deeply.
Lordship, may I, Lordship?
Lordship,
Today's matter, item number 16, Lordship, hearing matter, Lordship. Can it may be listed day after tomorrow, Lordship?
Day after tomorrow?
Yes, I have already taken consent from the petitioner council.
Okay. Miss Alage, Land additional PP for the state with the consent of Land Council for the petitioner. Prays for listing this matter on Wednesday.
Yes, Lordship.
20 on 28. The prayer is allowed. List it accordingly on 28.
My subject.
Lordship, may I beg to mention item number 6 on the behalf of UDECA. He's a respondent and we have taken the consent from the other side also. Council is out of station right now, Lordship. Can you maybe fix after someday?
Deka is for respondent.
Respondent.
Okay. Miss Dirilo, Land Council, submits that the Land Council for the respondent is out of station. Therefore, she, with the consent of Land Council for the appellant, prays for listing this matter after
2 weeks.
After 2 weeks. The prayer is allowed. List it according. List the matter after 2 weeks. Okay.
I want to mention item number, bail number 35. Bail number 35.
35 what?
35 2022. Bail number 35.
Yes. What bail number 35?
Bail number 35. A matter was fixed for today.
Today.
But in court,
Not listed.
there is not a fear.
Okay.
So, my lord, I request
So
to
call for if it is fixed for today. Too bad mention on that.
Yes, yes.
Actually, he's seeking mention memo lordship for today's lordship as an unlisted matter. You said that the bail matter is fixed for today only.
Yes. Last date given by Mr. Honorable.
Let us see. Let us see.
Fixed था पर ऑफिस में नहीं
Yes. Item number 1.
Well, the case in nutshell is that there was a land dispute between the petitioner and the respondent. it has a checkered history of some time more than some 50, 60 years back. And finally, the issue was brought up in the month of November 2025. And thereafter, what had happened, it was reported to one head Gangbura, the village authority of which village that is? Kamdi village. So finally, what had happened, on 12/1/2025, there was an authorization letter from the head GB of Kamdi village to conduct the Kava. And thereafter, like on the same day, my lord, the Kava members, they went and visited in another village and they held the Kava without issuing the Parwana. That is the first fatality in the law. And secondly, my lord, what had happened is, then appeal was preferred. My lord, I'll assist the court with the annexures. Well, thereafter, what had happened was, the petitioner herein has preferred an appeal under section 15(3) of the AP Civil Code before the senior division. Civil Judge Alo, my lord. Now, a simple question was framed on the issue of maintainability, my lord. And on the basis of the issue of maintainability only, the petition was dismissed, my lord. So, but which, to my understanding of the AP Civil Code, is a frontal attack on the statute, my lord. My lord, kindly come to the impugn judgment at page 107, my lord.
Yes.
My lord will kindly come, my lord. The fact is described up to para 4. Then kindly come to para 8, that is at page 110, my lord. 8, my lord.
Yes.
Para 8. Having heard the counsels for the parties, this court found that primary dispute pertains to the maintainability of the appeal, and according to the appellant's counsel, an appeal against a village authority decision is maintainable before this court under the third proviso to the section 15, subsection 3 of the AP Civil Code Act 2021. Conversely, the learned counsel for the respondent has contended that such appeals shall lie before the inter-village territorial customary apex court or apex customary court in terms of section 15, subsection 4 of the said act. Therefore, this court must frame a single issue to address the conflicting arguments of both learned counsels. Accordingly, the issue is framed for determination. The single issue, my lord, will see whether an appeal against the decision of a village authority lies before the civil court or inter-village customary court / apex court. My lord, the framing of issue itself is patently illegal in term of the fourth proviso. There, it is categorically provided that if the party agrees to, suppose one party, one litigant doesn't give the consent to appeal the decision of the village authority having original jurisdiction before the customary court or anything else, whichever name it is called, may approach to the civil court straight up. So here, my lord, before this, my lord, kindly come to the proviso is already provided in these para 9, lord. Kindly come straight, I'll take lordship. This is in this proviso, my lord. Initially in the 2021 Act, this proviso was not there, my lord. It was added by the amendment in 2022, my lord. Kindly see, my lord. Here I find the conflict of law. 4, proviso 4, my lord. That is at page number 112, my lord. An appeal from the village authority, if agreed to by the parties, my lord. Here was the definition, that interpretation that I was giving. If agreed to by the party means both the party indigenous to the state of Arunachal Pradesh must give the consent. shall lie before the inter-village territorial customary court or apex court, customary court, by whatever name called, we shall settle the case as per the local traditional customary laws under the proviso of section 40 of the Assam Frontier Administration of Justice Regulation 1945. Now, Malad, I'm pausing for a moment and give my interpretations here. Malad, the section 40 talks about the basic principle of the CPC shall be applied. Here, first, if there is a complaint that you see, then the head Gangbara will decide as to whether the summons would be issued or not. The summons would be issued, Milord. In this case, the summons has not been issued. Now, kindly come to page 113 straight, the last proviso, where this order is not sustainable in law. Provided further that the courts of civil judge, senior division, the court of civil judge, senior division, the courts of additional district judge, or the courts of district judge, as the case may be, shall not, my lord, kindly mark this, the word shall not is a mandatory provision by the statute, my lord, shall not set aside an appeal so filed merely on technical ground or procedural lapses, but in the interest of justice shall dispose of the same as may be deemed appropriate or proceed with the case de novo. Number one, the statute clearly provides you that you shall not dismiss any petition or set aside any application by quoting a wrong provision of law also, you cannot. One. And number two, the statute has empowered you to take the case de novo by yourself, my lord. So dehouse the mandate and objective of the statute, this impugned order has been rendered, my lord. Then I read it. Then, my lord, page 112, my lord, kindly come back. I always oblige the youngers who assist me, my lord, to insist to read certain things.
Yes.
Second proviso of the proviso formula, second paragraph.
Yes.
Provided that an appeal against the order of inter-village territorial court or apex customary court shall lie before the courts of civil judge, junior division. After this, which paragraph? 112. Okay. Above, before the fourth proviso, last. Page 112, my lord, para 1, 2, 3. Provided further also that where the deputy, am I correct? Provided further also that where the deputy commissioner has already transferred pending appeals of pending civil suits of the court of. No, I'm reading. Under 12. So there is small confusion, my lord, once. Under 12, second paragraph, my lord, straight. Provided also that in case an appeal is transferred by the deputy commissioner or preferred against the judgment of the customary courts in the courts of civil judge senior division, the courts of civil judge senior division, the courts of additional district judge or the court of district judge, as the case may be, such appeal shall not be set aside merely on technical ground or procedural lapses, but in the interest of justice shall be disposed of as may be deemed appropriate or proceed with the case de novo. He cannot listen to you. That is the respectful submission. Well, these, fine. Well, these honorable court interpreting the proviso 4 of the newly amended, my lord, in CRP number 43, where is that? Please pass on this. Civil code. Kindly come to para 3. The fact of the case is similarly situated, my lord. The short question arising in the present proceeding is to whether the inter-village territorial customary court which had decided the issue would have an original jurisdiction in the matter and or can only have an appellate jurisdiction after the issue was so decided by the jurisdictional village authority.
No, you're challenging which one?
That para 3, my lord, internal page 2 of the judgment.
Impugn order passed by the civil judge.
Here, dealing with that particular proviso, this honorable court in this judgment has made an observation that I'm coming to, my lord. That's why I'm referring to this judgment. The fact is civil dispute, land, my lord, in the paragraph 2, my lord, will come. The question which this honorable court framed in CRP number 43 is that the short question arising in the present proceeding is as to whether the inter-village territorial customary court, which had decided the issue would have an original jurisdiction in the matter and or can only have an appellate jurisdiction after the issue was so decided by the jurisdictional village authority. Here, my lord, I'm pausing for a moment to give my clarifications, my lord. Number one, my lord, has seen, kindly come to page 25 for a moment. 25 is type copy, my lord. This
20
head Kangura of Kamdi village, my lord, has given authorization on 12/2/2025, my lord.
No, whatever may be, the Kaba decided, but then you file appeal before the civil judge only.
My lord, I'm just connecting the fact
Okay.
how in the paragraph 3 of the CRP 43.
Hmm.
So here I'm connecting, my lord. On the same day, my lord, what had happened is he has given the authorization due to pressure exerted from the respondent side. And my lord, next page, kindly see,
What is this, 26 page?
authorization letter, my lord,
Authorization for what?
to conduct the Kaba.
Kaba, what, inter-village?
Not inter-village, my lord. Which village we do not know, my lord. He is from another village, right? He is from Dharka, my lord.
When? This was when?
This was on 12/2/2025.
And when the impugn order was passed?
Same day, my lord.
Just a minute.
Kindly come to this thing, my lord. Page 30 is the type copy, my lord.
After filing appeal.
No, my lord. No appeal, nothing was there. On that day, the authorization was given or per se empowered the another GB to conduct the Kaba. And this GB has not issued the Parwana as required under section 40. Then what had happened on the same day, this order was passed, my lord.
Are you challenging the Kaba order also?
No, I'm not challenging, my lord. Just I'm referring to the facts of
Okay,
this
just-
matter. How the
Well, kindly let us read this one.
Yeah.
I so and so.
which one, my lord, is
No, page 26.
page 26.
What do you want to show by this?
Page that is the meeting, my lord. 26. 26 is the authorization letter to conduct the Kaba.
Hmm? Hmm.
I, Sri so and so, HGB Kamdi, POPS, Alo, West Siang District, AP, on today's Keba in between Sri Doji, Sri so and so regarding their boundary dispute, authorized Sri Dui Ete, GB, Dharka village, another village. That means, my lord, it is a inter-village, inter-territorial customary court.
Hmm.
And this court has already held that they cannot assume original jurisdiction unless the competent village authority decides the case. So this authorization, my lord, or after this authorization, what had happened is this Kaba decision at Annexure 4, page 27 was rendered without following the due process of law. My lord.
27 is
The
Kaba decision.
Kaba decision, my lord, that which we are not impugning.
So this authorization is dated 12/2/25.
Correct, my lord. This was also passed on 12 on the same day. My lord.
12/2/25.
Yes.
And
the
then the Kaba order is
Same
dated?
date. Same date.
on dated so and so.
Hmm.
No, 12/3. This is 12/3. Okay, this matter. 12/3 or when?
12/3. Here it is written 12 January.
Hmm?
It is written 12 January 2025. And the Keba order was also passed on 12 January on the same day.
This, no, this authorization is 12 February.
Is there a typographical mistake? But 12-1, madam.
It shows 12/2.
I think there
Type-
is a typo mistake from this angle, madam. Type copy, there is some typo mistake, madam. Original copy.
No, and in the original authorization letter is 12/1/24. But then in the type copy, it is 12/2/25.
This typological mistake is there.
I don't know.
Mistake here. You're not supposed to do.
See, 24, one is 24, one is 25.
Madam, kindly see the right side.
No, right side,
Page
that is one,
25.
12/1/2024.
Huh.
Authorization is 24, 1 year back.
1 year back. And this another doubt is created here, 9/2/2025, left side. On the
Hmm?
same page, page 25 in the original copy.
Original,
Page 25, if my lord can come flip back,
yes, 12/1/2024.
correct. And left is 9/2/2025.
Left. No, that is, I think,
Do you have that?
CTC or what?
No, no, no. Can we cross check this? This is not correct.
This is not a, this is not the sign in the authorization.
Do you attach the chairman, my lord? The authorization is, and then this is 12. This is 12. And the
So many
same day,
dates. 12/1/2024, 9/2/2025, and type is 12/2/2025. All different dates. Okay, but then we are not here.
we are
I
not
think
here. But just I am connecting the case, my lord, how on the same date the Kaba
it
decision.
probably is not on the same day.
Yes. Then what had happened is, my lord, this impugn order was rendered, and whereby the single question was framed on the issue of maintainability. As lordship, we had gone through that particular thing, my lord. Now, my lord will kindly come to the impugn order, my lord.
Hmm.
The fact we already have dealt with. Page 110 is the issue that the learned trial court has framed. And then he has extracted, the learned judge has extracted.
So,
From penal.
you mean to say that in view of the subsection 4 of the section 15,
Correct.
so since there was no agreement between the party,
No agreement between the parties.
so the learned civil judge could have decided.
Could have decided, and
Hmm.
even he will have at the first instant,
Hmm.
he should not,
Okay, will issue notice.
and will not kindly stay this. There is one judgment by this court
Okay.
also on this, which we read.
This one.
Yes, no.
Okay, add Mr. T. Tara, Learned Senior Counsel, assisted by Mr. Bam, Learned Counsel for the petitioner.
Please check that. Don't do this. Not proper.
Start, huh? This application under Article 227 of the Constitution of India is directed against the judgment and decree dated 11/3/2020. This is judgment and decree. Okay. Dated 11/3/2026, passed by the Court of Learned Court of Civil Judge Senior Division in Civil Appeal number 04/2025. whereby the learned court dismissed the appeal is not maintainable on the ground that the appeal lies before the inter-village customary court, stroke apex customary court. And what is the further direction?
Para in the impute judgment, below.
What is the further direction after dismissing parent
Okay.
approach?
Approach.
Hmm.
Appropriate for. Page 115, below.
Yes, yes.
Para 7. sir.
And directed to approach inter-village customary court.
That is Bango level government making mandatory to approach with
That is Bango level Kaba authority or the apex customary court. That is the district level Kaba authority. Start, huh? Para. It is submitted that in view of the subsection 4 of section 15 of the Arunachal Pradesh Civil Code Act 2021, this is amended,
amended. 22 amended.
amended 22, huh? 22.
My lord will find at page 126, the amended provision. 22. 26. Roman 3, my lord will find after the fourth proviso to the subsection 3 of section 15.
Yes, if agreed to by the parties.
Correct.
Could not have set aside the appeal and by passing the impugned order, the learned civil judge has where is your allegation is exceeded the jurisdiction or
Has not
Or-
exercised the jurisdiction
Okay.
in accordance with.
failed to exercise the jurisdiction conferred on it. Staff issue notice returnable by 4 weeks. The petitioner shall takes step for notice upon the respondent by a speed post as well as by user process within a week from today. Staff. List this matter after 4 weeks. Staff. In the meantime, the operation of the impugned judgment and order dated
11/3/2026.
11/3/2026 shall remain stayed till the next returnable date. Okay.
My lord, I apologize for this typographical
No,
mistake.
probably you have to correct it
Yes,
because
my lord,
it's
as a
25.
legal counsel, we are barred from doing these kind of things. So
So
I'll
you
not
say
blame, but I'll
the
make
junior should do.
Yes, my
Mhm.
handles will not.
So probably you may have to replace this because your type is 25. And then in the written, handwritten is 24. Year also and a date also, month also.
My lord,
Mr. Okay, the additional counsel further praise for allowing him to correct the typological error in the
my lord will write page number 25 and
this is translation.
Translation copy.
A translation copy of the, this is
Authorization letter.
authorization letter, okay,
Authorization
authorization
and the
letter,
cover decision.
authorization letter.
Oh,
This is annexure,
annexure.
annexure 3, huh?
Annexure 3 and form.
Annexure, authorization letter and
And the
and
cover
impugned cover decision at annexure 3 and 4 respectively. The prayer is allowed. Okay, the correction be made within a week from today.
Right.
Okay, okay.
One more assistance to the court, Miller.
Hmm.
In the 2023 amendment,
Hmm.
what I have noticed is it shall be deemed to have come into force with effect from 20th February 1987. So meaning thereby, even our Registrar General judgment, Navam Nikum judgment,
Where?
well, kindly come to page 127. That means our councillors have to be careful while quoting the law now.
Mhm.
My lord, we'll see this serial number 1.
Hmm.
Kindly come to serial number 3.
Hmm.
It shall be deemed to have come into force with
Serial number 3,
3 years. One serial number
page 127
127.
is Arunachal Pradesh Gazette
Gazette
notification.
notification is 12 April 2023, the amendment. Law.
Yes,
Where Act number 4 of 2023,
yes.
the further to amend the Assam frontier so and so, be it elected by the Legislative Assembly of Arunachal Pradesh in the 74th year of Republic of India as follows.
Hmm.
Short title will not read, Milord. Kindly
Hmm.
come to 3 straight, Milord.
Yes.
It shall be deemed to have come into force with effect from 20th February 1987.
Section 3
Yes, Milord.
in the principle.
So that means the law, although was enacted in 2021,
Where do we find that it shall be deemed to?
it's well, just short title, my lord, is in serial number 1.
Yes.
Then after
2
that,
is
my
amendment
lord,
of clause,
3, my lord, will see.
amendment of section 2.
No. The after 1 there is a Roman 2, then 3. It shall be deemed to have.
Hmm.
But short
After
title-
2,
After 2, my lord.
amendment of
No.
clause B.
No, my lord. Page, my lord, is
Yes, okay. In 1,
120.
subclause 3.
3 subclause.
Okay. It
And-
shall be deemed to have come into force with effect from,
20th February 1980.
yes.
So that means, my lord, that the ratio later.
No,
Kindly see this, my lord, because they have a very,
I think there will be problem.
there will be a problem in this.
This probably we have not noticed.
No, just I was reading through again this morning, and I noticed this, my lord. I think our friends have to be careful now,
Mhm.
quoting the certain ratios.
Come into force with
Yeah.
effect from 20th February.
We have to see the constitutional parameters
Mhm.
of lawmaking power of the state,
Okay,
because whatever it is under 246, then my lord, the entry 2 is important for us. Whether under entry list 66 or 67, we have this kind of.
okay.
I'm grateful.
Okay, thank you.
In that sense.
Item number 2.
Yes.
The petitioner before your lordship is a 17-year-old man who is also ailing,
17,
9-year-old.
79.
Not the petitioner,
Petitioner is,
79-year-old man. He
okay.
is ailing. So in this petition, I am challenging the execution proceeding, execution order passed by the learned Civil Judge Senior Division Pasighat. So before I take my lord to the execution case, I just want to take your lordship to few of the documents which are initially important. That is the plaint and the written statement and the order.
Hmm.
I'll take your lordship to page number 31 first, which is the type copy. This is the plaint which was first filed by the one tossing tying plaintiff against one opaque Rome. Your lordship has gone.
Yes.
Thereafter, what happened? The plaintiff passed away, and his son was subsequently taken over the place of the plaintiff, which your lordship will find at page number 44, which is the type copy.
Now, what was the prayer there?
Yes. The prayer in the main plaint, which lordship will find page number 35.
Yes.
Yes. The relevant portion, page number 36. The plaintiffs pray for a decree against the defendant for immediate delivery.
Delivery of possession is there?
Yes. Ownership of the plot of land for delivery of another plot of land if the delivery of plot of land is not possible, for cost of the suit, for any other relief which the plaintiff is entitled to.
Now, we are concerned with the delivery of possession.
Yes, I'll take you. I'll take
Okay.
your lordship to that.
Okay.
Thereafter, the scheduled land was marked as one pura approximate land. Your lordship has got this. Now I'll take your lordship to the second plaint, when the plaint was subsequently, when the son of the initial plaintiff came into his shoes, which is at page number 44, the
Just
type
a-
copy.
Just a minute.
Yes.
Just a minute. There is a prayer for delivery of possession
Yes.
in the beginning, that is
Yes.
in the year 1993.
Yes.
Okay. Next page.
Page number 44. In the first plaint, one thing your lordship will note, I am not with the party. I was
This
not a
is-
part. I was not the party in the first plaint. This is
Okay.
the second plaint which was filed
By
by the son of the plaintiff
Tasing Tai
after his demise. Talom Taing,
is son of Tasing Tai.
Tasi Taing. After his demise, he got pleaded, he filed a fresh plaint. In this
Fresh?
plaint, yes, lordship. This is a fresh plaint.
Not the same. No,
Not the
it's
same.
Title suit same.
Title suit is same.
TS3.
Yes, that's what I'll take your lordship.
Okay.
Here I was impleaded as pro forma defendant number 2. Your lordship has gotten page number
This was
44.
basically against one OPAC.
One opaque Rome. I was impleaded as pro forma defendant number
You are
2.
performer,
Yes,
93.
yes. And the
Prayer
relevant portion, the
Prayer.
prayer, I'll take your lordship to the prayer portion, which is
49.
important for this case. I won't take trouble your lordship with all the documents.
Hmm.
Page number 49.
Hmm.
Plaintiffs crave judgment and decree for declaration of title, ownership, interest, and for confirmation of possession of the land in question in favor of plaintiff. Meaning thereby, the plaintiff is in possession of the land. Cost of the suit, any other suit. So, and page number 50.
No, sir, in the earlier prayer, it was for delivery
Yes,
of the possession as well.
yes. But subsequently, they said they seek for confirmation of possession.
Okay. They then,
Yes, 49, because meaning thereby they are in possession of the property. Page number 49.
just a minute, sir.
Yes, lordship.
So immediate delivery, it was in the 7th May, 93. And
Yes.
this was filed on 22 November.
90.
By then, it appears he has taken possession.
Yes.
So now he prays for confirmation of the of his possession.
Yes, much obliged, lordship. This is the correct status right now. And the land in question is page number 50. Scheduled land, plot of land measuring 1 pura situated at village so and so. The scheduled land is the same. It's a 1 pura land.
Hmm.
Now I'll like to take your lordship. Thereafter, the defendant appear, opaque Rome. He filed 4 number of WS. There are 4 written statements by the defendant. And finally, he filed an additional written statement which was not even considered.
Just a minute.
I have filed 1 number of written
Just a
statement.
minute, for staying there.
Yes.
Okay, Keba decided,
Yes.
in whose favor?
Kebang, so what happened, Lordship? Thereafter, Kebang decided in my favor first. There were two Kebangs, it decided in my favor. Thereafter, it went to it went before the district judge. District judge decided against me. Thereafter, I have come before this honorable court. Honorable court decided in my favor. Again, the plaintiff went back to Supreme Court. Supreme Court remanded the matter back to the district judge to decide afresh. So that's why I want to, that's why I want to take your lordship to the order
Supreme
passed
Court,
by the district
it
judge.
went to Supreme Court also.
Yes, Supreme Court
Supreme
sent back
Court decided, sent back to,
the district judge to decide afresh.
okay, then what the
So district judge, I'll take your lordship to the order passed by the district judge, which is at page number 164.
Yes,
So there were around 29 issues which were framed, which your lordship will find page number 167.
then who is
Initial-
this then?
167.
No.
Lordship has gotten
Who,
167.
this is again different person, it appears.
So it actually what happened thereafter, he also passed away. The initial plaintiff passed away. So his wife got implicated. Anima Tayeng.
Initial plaintiff passed away.
Yes, the son
The
got implicated,
son-
then son
son.
passed away, then his wife got.
Okay, why?
Wife is there
Now
before
it's
your
the
lordship
wife.
now. Yes. So wife
Okay.
is there. So your lordship will find the prayer at page number 167. So sorry, the issues which were framed initially is at page number 167. Your lordship will find there was one issue which was framed.
Whether case is maintainable in its present form, just a minute, whether this issue was there, delivery.
Yes, that's what I would like to. That's why there were around 29 issues. Out of the 29 issues, page number 169,
Hmm.
there was one issue whether the plaintiff is in possession of the land.
Hmm.
Because he have claimed confirmation of possession. Your lordship
Issue
has seen
number
24.
24.
Yes,
Plaintiff is in possession of land.
yes. This issue didn't get answered. There was no answer. I will take your lordship. There is no answer to this issue. It was skipped. Thereafter, I have assailed the said order before this honorable, and it went against me, this order. So in this order, I'll take your lordship to page number 206.
So here, this is judgment.
Yes.
Is this
206.
an impugn order?
No, not, this is not the impugn. I am challenging the execution, lordship.
Okay.
This
So
is,
what was the decision there?
yeah, decision was, so the plaintiff have sought for confirmation of possession. Now, the order which was passed, the relevant portion is at page number 206. I'll take your lordship.
Hmm.
The plaintiff shall have the right title over the disputed land measuring 1 pura,
Yes.
which is equivalent to so and so meter plus 30 feet adjacent land.
Hmm.
So the district judge went ahead and gave over extra 30 feet adjacent land. Lordship has got
This was not the issue.
not an issue. Now, subsequently, page 207,
Hmm.
permanent injunction granting restraining to defendants and their employee agents, if any, form encroaching over the suit in any manner.
Hmm.
Now, my lord is well aware, this was a suit for a specific relief act. There, my lord has seen, there is no prayer for permanent injunction. But
No
still,
prayer for?
permanent injunction, restraining defendant. But the district judge went beyond the jurisdiction and gave a relief. Thereafter, we have approached. So these are the reliefs which was given to the,
You challenge this
yes,
judgment.
I have challenged this judgment before this honorable court.
Okay. What was the order?
This honorable court upheld the order of the district judge.
Okay.
Thereafter, we have challenged this order in review, which is pending before this honorable court itself. In the meantime, what happened? Lordship, page number 267. The review application is pending, which is numbered as 2 of 25.
Hmm.
So now 267, my lord have seen.
Yes.
Page number 267.
Any order passed in the review?
No, there is a notice has been issued in review case, Lordship.
Hmm.
Lordship, then 267, page number 268 is the relevant portion.
Hmm.
269, Lordship.
Hmm.
The ju- Lordship 270, my apologies, Lordship. 269, last point number 7. Particulars of the property, decree holder having the absolute interest over the land property measuring so permanent injunction against the defendant, against whom to be executed, against both judgment debtor, exemptor. 11. Now I'll take your Lordship to 11 point.
Hmm.
By delivery of possession of land measuring so and so feet of the property showing below, order for vacating of the land. Now they have asked for vacating the land. When you have sought, in the
Admitting,
plain-
thereby admitting that it was.
they are not
your
in position. They have simply misled this honorable court all throughout, Lordship.
position.
They have been in their
Right,
pleadings, they
yeah,
have been stating they are in confirmation of possession. So what is the remedy, Lordship, available? They should have amended their plaint, or they should have informed their plaint.
30 feet within the schedule of the property. Don't believe it.
So firstly, they should have at least informed the court that they are not in possession. They should have amendment because it was a suit for specific performance of a sale deed. And they never came before this court and stated that we have been dispossessed. Court has passed a decree. And now they come and say they want eviction, a fresh cause of action they have sought by way of execution. This is a way, it's a shortcut way. So I have filed my objection, written objection, which is at 273. And the impugned order, my lord will find at page number 276. May I take your lordship? This is very important, lordship.
Hmm.
This order. It's not a big order, it's a short order. May I read few lines, lordship, from the order?
Yes.
So heard so and so, the execution petition has been filed to execute a decree passed by so and so. For the land, it is ordered that title suit. This is the portion permanent granting injunction, the land and so. The relevant portion I'll read is, yes, 278 page number. The learned counsel for judgment debtor has vehemently argued that a land in question is in possession of judgment debtor since before filing of the suit, but consequential relief for recovery of possession was not prayed for in the title suit, as such decree is not executable.
Hmm.
On the other hand, learned counsel for decree holder has submitted that the land in question was in possession of decree holder when the title suit was filed. Therefore, specific prayer was made in the plaint for confirmation of possession of land in question in favor of decree holder. Meaning thereby, decree holder now comes in the execution and say, at the time of filing, it was there in their possession. Now they have been dispossessed. So what is the remedy as per the civil procedure code? You have to inform the court, you have to amend your pleadings, or if I have violated any order of this honorable court, a violation application should have been placed before the trial judge. Nothing was done. Thereafter, what is there? Having heard the rival contention, it is imperative to address whether the land in question was in possession of decree holder or judgment debtor. Now the court itself is saying it is not clear whether the land was with judgment debtor or with the decree holder. Because the prayer of consequential relief, that is recovery of possession, is necessary if the possession of land was with judgment debtor. The court itself have stated this fact. According to the case record, title suit so and so in original suit filed by the decree holder, and in cost title itself mentioned the suit was for declaration, title, ownership, interest, confirmation of possession of the scheduled land, and in the prayer part also decree holder had specifically prayed confirmation of possession of land in question in favor of decree holder. Therefore, it is apparent that the decree holder had possession of land in question. Hence, he prayed confirmation of possession of the land. In para 4 and 5 of the plain, the decree holder plaintiff have categorically mentioned that the decree holder plaintiff took possession of the land in question for purchasing the same from the father of the defendant. Therefore, there are 4 contradictory written statements of the defendants. The defendants had categorically admitted the contention of the decree holder. Further, the judgment debtor, pro forma debtor who examined DW has admitted that the decree holder plaintiff was in possession of land since 1994. Therefore, this court holds that the land in question was in possession of a decree holder. So, the executing court has put its shoes in a trial court's order. Now, the Lords. Thereafter, what happens? When the right title over the
What
dispute
was your contention in the written statement?
written statement, Lordship, we have denied their possession. We have in fact stated there was a land was given to me via sale deed. It was an oral execution. So, and in their sale deed,
You also know the actual
And
owner
I am-
sold.
no, that's why review is pending, Lordship. So that is the reason I am before your Lordship. So what is the final?
Your claim is also on the base.
Yes, of a
basis of
sale
the-
deed, Lordship.
Okay,
So now what is the?
difficult.
So now what the district judge has stated, just because it is going to cause an hardship, that's why I am allowing the decree. That is not the settled position of law.
What was the evidence with regards to the possession?
Possession, Lordship, it is a mix. Some are saying I am in possession, some are saying they are in possession. So that also a question
No,
was
any
not.
committee constituted to visit the.
Lordship,
No.
sorry.
No, any committee or any.
No, nothing, Lordship. That is the difficult part. So Lordship will see, I'll take your Lordship to, I have shown your Lordship the order. I'll take your Lordship to the judgment passed by the Honorable Apex Court. This is the very latest judgment.
Yes, what it says.
Yes.
Sarah?
Page, para number 20 onwards. Page number 4.
Yes.
The preliminary argument of the plaintiff is that the executing court cannot go beyond the decree and
That-
has to execute, which your Lordship is well aware is a settled position. The executing court cannot go beyond the decree, has to execute the decree as it stands without making any modification thereof. Therefore, the executing court manifestly erred in passing an order dated so-and-so and order dated so-and-so on review petition. From the side of the defendant, it is submitted that the executing court has rightly interpreted so-and-so. The counsel for the defendant, para 22. Defendant, respondent relied so-and-so. Now 23 from 23 onwards. In order to address the controversy in appeal, it would be profitable for the first place section 47 of the CPC, which provides that the question to be determined by the executing court. The aforesaid section 47 is reproduced here in below. The 47 is written, the question to be determined by the executing court. Now, a plain reading of the aforesaid provision makes it clear that the executing court is empowered to decide questions relating to the execution, discharge, and satisfaction of the decree, and has no jurisdiction to go beyond the decree. Now the executing court is giving an eviction from the property, sought to be executed. In other words, it has to be executed, the decree in without changing the same. It is a settled law that the jurisdiction of the execution court is very limited to give effect to the decree as it passed and not to assume the role of a trial court. Now, in my case, the executing court has become a trial court. It went back and said,
Now, otherwise,
yes, Lordship.
except for the delivery of possession,
Yes,
so the case is in favor of the respondent,
yes,
except for delivery.
delivery.
Now, you are still claiming that it is under your possession.
I am in possession, Lordship. So now I am a
In
7, Lordship.
93.
Yes. Now Lordship will see one thing. I am
See-
79 year at this stage, Lordship, at this stage, since it's a motion stage, I just pray the issuance of notice and stay of execution proceeding till the returnable date.
No, it's not possible. Since 93, you are causing trouble.
No, no, Lordship. There is no prayer.
Will issue notice.
Lordship, the court went beyond one judgment, one more judgment I would just like to place
Okay.
with regards
Hard,
to
Mr.
hardship.
Hard, Mr.
F for the Lordship.
Learned counsel for the petitioner. See, since 93, the person could not enjoy the fruit of the land he purchased.
Lordship,
And
this,
one
for that
pretext or
one,
other
this judgment.
pretext, you drag him till
No, no, Lordship.
Supreme Court.
Lordship, I have not dragged him, Lordship. In two of the decision, I won, one he won. So that is the reason I am before, and a review is also pending, Lordship. My review will be
Re-
in
No order was passed. When the
one aspect, our page number-
when High Court passed order?
review application. Review petition is of 25, Lordship, 2 of 25.
25. Okay.
Yes.
And then High Court judge or order judgment is
High Court judgment is, 1 second. Lordship. Yes. 1 second. High Court judgment. 24, Lordship. 25-10, 24, Lordship. Lordship, one small aspect before my Lord, one judgment which I have placed of 2008 for SCC. Yes. In this judgment, I'll just read one part. Paragraph 32, only one paragraph, Lordship. What the Honorable Supreme Court has said, similar facts, Lordship, like this. One aspect which I would like to state, that the trial court has stated it will cause delay. With regards to that, the Honorable Supreme Court has stated, we are of the conscious fact. May I read, Lordship? Lordship has got
yes.
paragraph 32. This is with regards to the delay. We are of the conscious fact that the suit was filed in the year 1978 and driving the plaintiff to fresh round of litigation after 3 decades would cause hardship to them, as fallen from your Lordship. But the scope of civil cases are circumcised by limitation placed by the rules of pleadings, nature of relief claim, and the court fee paid. So the Honorable Apex Court states that although,
No. So there was an issue also,
yes,
and
so-
then
but the scope of civil
respondent
cases
has made
are
specific prayer for delivery also.
no,
And subsequently,
there was
over
no
the
prayer
year-
for delivery.
No, earlier we have seen.
No, that plaint is not considered because they have filed an amended plaint.
Mhm.
Because they have sought confirmation. When they file amended plaint, the previous plaint goes.
Now over the year,
But there should be some application.
where
that
where
they
is
are
the
not-
location? It's in the town area or
Pasighat.
somewhere,
Village.
village. That's why sometime in your possession, in his absence.
So Lordship, but
But
there
then
are,
ultimately, the land belongs to him.
no, we are staying there. We have a house there, Lordship. Lordship will see this paragraph 32, it clearly states, Honorable
See.
Apex Court, Lordship.
If that be so, the
No,
order would have
I
been
am not
different.
I am not praying, my Lord.
You said that sometime it's,
No, I am not praying, my Lord, for a extended stay. I am just, your Lordship may fix after 2 weeks. Till that date, at least let them come. We will issue notice by Dasti. We'll take a Dasti steps.
see,
That's the only small prayer, Lordship, nothing else, Lordship. Because I am also, Lordship, me also consider, I am also 75-year-old ailing man. If today I am thrown out of my house,
your claim is based on what?
my claim is based on a sale deed itself.
Verbal,
Yeah, oral agreement.
oral
My
agreement.
father-in-law gave me the property
And his claim is on the basis of,
of a unregistered sale deed. His also claim is based on unregistered deed, not a registered deed, Lordship.
which has a better claim? Unregistered, written, signed, and
No.
oral.
Until the deeds are proved,
Hmm.
no one has a better claim, Lordship.
Unless it is proved, how the court will decide that?
No, I am not I am not on that matter. That's what I am placed before Lordship at the first instant. The matter is still sub judice in a review application.
Review, no order was passed. Any stay?
No, stay is not there, but notice
Then-
was issued, Lordship. In review.
Then,
Lordship, and moreover, we were in possession since then. So now suddenly if the court comes and disposes me, it becomes a bit difficult, Lordship. So that is the only ground. I am not saying I don't want at least 2 weeks time may be given till returnable date. We will take a steps by Dusty.
This petition. Hard, Mr. Huh?
F for it, Lordship.
Okay. Learning Council for the petitioner, stop. The petitioner filed this petition under Article 2027 of the Constitution of India, read with Section 15 of the Code of Civil Procedure. Challenging. Where is the impugn order?
Impugn order at page number 276, Lordship.
The order dated 10/3/2026 passed
Yes.
by the Law and Civil Judge Senior Division, Pasigat, in execution case number 10 of 2024,
Yes.
in title suit number 7 of the 2012.
Yes.
Whereby this application, your application was,
My objection was
whereby the objection filed by the petitioner was rejected
yes, rejected.
and directed removal of structure standing over the suit lane. No, rejected, stop. It is submitted that, it is submitted that although no decree for recovery or delivery of horse possession was ever passed, the learned executing court has directed for removal of structure standing over the suit lane and delivery of possession to the decree holder. Along with the delivery of possession of additional 30 feet adjacent lane. And thereby the order suffers from jurisdictional error. And then, and thereby the learned executing court has traveled beyond the decree. Stop, huh? Issue notice. Returnable by 4 weeks. Stop. The petitioner shall take steps for service of notice upon the respondent by a speed post as well as by usual process within a week from today. Stop. List this matter after. No, again, a call for the records also, huh?
Yes.
Call for the record also. List this matter after 4 weeks. Stop, huh? In the meantime, the party shall maintain status quo over the suit until the next returnable date.
Much of. Much of.
Item number 3.
Your Lordship, this
pre-arrest bail application. In this case, there are two accused are given. One accused have been already granted pre-arrest bail by the Honorable Court.
You are the one who assaulted.
Yes, in allegation,
Then-
I'm the one who have been assaulted.
And then it was rejected.
And Your Honor, the,
Anticipated bail was earlier rejected.
yes, before the district and session court.
Okay, it was in the year 2024.
Yes, ground of rejection.
Police is not interested to arrest you. What you are worrying about?
Your Honor, on 12 of this month,
Police will not arrest you, never arrest you because you have managed, it appears. Since 2024, you have not been arrested. You don't need any protection.
Your Honor, here, kindly see the page number 28.
Yes,
That, first my bail application was rejected because MLC report was not sent by the KSIO. But when this, Honorable Court saw that report, here in page number 28, para 7. The learned additional PP of the court is there, drawing my attention to the medical report.
Mhm.
That
yes.
the injury.
CD incomplete. See, the case diary was produced incomplete before the court.
In page number
So
28,
police is not interested.
in page number 28 of my petition.
2A,
Para 7.
what is that?
Here the case diary, in case diary that the MLC report was sent.
Hmm?
And here that the injury was simple injury, Your Honor.
Okay, but then why he could not move? Why you have paid so much of money if it was only a simple injury? You paid how much money?
150.
450,
150.
150 only.
Yes, Your Honor.
Why if it was only a simple injury for
Since he
treatment,
was working at the house of that poet.
but you have
and-
assaulted?
Some amount was remained to pay what she have done house work at this at our house. The pending amount.
Police is not interested to arrest you, in arresting you.
Now repeated.
No, you said that, huh?
That injury is simple injury. Your Honor.
You said that you have taken the responsibility of treating the person,
Simple injury.
treatment, you are also bearing the expenses of the treatment for the injury of the informant. If it was a simple injury, they don't require such treatment. And subsequently also there was a complaint. It appears that this shows that you have forcefully obtained the signature. And then this lodge complaint FIR again after that also.
No, Your Honor. Complaint was made before they use the
See, it becomes very difficult when the court knows your conduct, knowing that the fact is something different. It's very difficult to protect the person who has done something and then claim something.
Your Honor, here I haven't alleged only that I have.
This could be seen.
And as per the FIR, there was very in FIR there was very serious allegation. However, as per the MLC report, there was no such serious allegation. Serious injury was here. In the parity, Your Honor, the same condition so that this jail application will be disposed.
Okay, so we'll call for the case that, Mr.
There, Bodhan.
What is the status of the case?
Still investigating.
Okay,
And
since
Your Honor,
2024.
Yes, only the statement of this applicant is remained to be reported. As per the case that is sent by the case.
Applicant means
Yes,
the accused.
yes. Only this is remain now. As per the case that is sent by KSIO before the Honorable Court in previous.
Where is your address?
Yes, sir. Naharlagan G sector.
Okay. But you could, what happened to the police? We need Interpol to trace him out. It's very difficult.
Only my allegations. I have been alleged that I have assault very seriously.
Mr.
Yeah, brother.
Line counsel for the petitioner. Also had Mr. Tado, G Tado, line additional PP for the state staff para. This is an application filed under section 482 of BNSS 2023. Seeking granting of pre-arrest then apprehending his arrest in connection with Nahalagan PS case number 24/2024 under section 343, 326 is 326. How it is simple? 317 IPC read with section 14 of Child Labor Prohibition and Regulation Act 1986 and section 75 and 79 of the Juvenile Justice Care and Protection Act 2015. Start. No? Since the case is of 2024 and the matter is stated to be still under investigation, this court would like to peruse the case diary. Accordingly, call for the case diary. Start. List this matter again.
There was ethics, the sort that, and no interpret for the
Give the date when?
18.
13.
21.
21. 21 is Thursday. Not on Thursday.
10.
Okay. 22. Okay.
Protection will be given.
You don't require.
Only, I have been alleged that I have caused assault at serious.
That was way back in the 2024. You will not be arrested.
Meanwhile, Your Honor, that about the party came before this honorable court for causing of the FIR and case was pending. During those days also that the applicant was cooperating with the investigating officer. However, due to some technical issue that the causing petition was withdrawn. And after
What technical issues? Why it was withdrawn?
there was certain mistake in
Okay. Why you did not file again?
that was withdrawn after in year 2025.
Okay.
And when Your Honor that the as per the MLC reporting very was simple. And in FIR
226. 226. We do not know.
26.
We do not know. The police also did not produce the entire case diary before the court when it was called for.
Before this honorable court, Your Honor, case diary was produced.
Case diary was in respect of the lady who did not assault. Okay.
Item number 4.
Yes.
Am I allowed to withdraw the petition?
You want to withdraw? Hmm?
I'm withdrawing the
Okay.
20 to 5.
Okay. Mr. T. Lamgu, Land Council for the petitioner wants to withdraw this. Praise for allow him to withdraw this criminal petition with liberty to correct the liberty to file afresh after making necessary correction in the error. Stop. Correction to the error. Stop. Making necessary correction. That will do. Stop. The prayer is allowed. This criminal petition is dismissed on withdrawn with liberty is prayed for. Okay.
Item number 5.
Please, madam. Madam, in this case,
The petitioner is assailing the order passed by the Learned Judicial Magistrate First Class Tawan.
Oh, just a minute, the one, Mr. Lamgu. Probably you need to, if it was a consensus, you don't have to make the informant or the respondent as a respondent. It has to be the consensus. Obtain some signature, I think that will do. Otherwise, nothing. I thought of disposing, but you are withdrawing what to do. Okay. Okay. Okay, correct it and file it. Okay. Yes, Mr.
My Lord,
P.
I'm assailing the order passed by the Learned Judicial Magistrate First Class Tawan, whereby a cognizance has been taken against the petitioner on the basis of the protest petition filed by the respondent herein. My
Can it be?
Lordship, since
Because he has to, the learned magistrate has to record the satisfaction
Yes, Lordship.
or dissatisfaction.
Yes, Lordship.
So that probably has not recorded here in this case.
yes,
How he is affected otherwise?
since my Lord,
Hmm.
there was an FIR initially.
Hmm.
That FIR has been culminated into closure report. And
Hmm.
unless and until, my Lord, there's any finding with regard to the disagreement of that
No,
FIR,
that is why I'm saying
my Lord.
how the complainant is otherwise also affected. It's okay. Well, issue notice.
Lordship.
Okay.
Until
In the
then, my-
meantime, we'll stay.
Yes, Lordship.
Mr. JTK, Learned Counsel for the petitioner. Also had Mr. Lloyd, Learned PP for the state staff. This is an application filed under section 528 of the BNSS 2023. Praying for quashing of the order dated 22/1/2026 passed by the Learned Judicial Magistrate First Class Tawan in IA number 7/2025 arising out of GR case number 8/2025 corresponding to Jang PS case number 2/2025 whereby cognizance under section 318 stroke 336 stroke 338 stroke 340 of the Bharatiya Nyaya Sanhita 2023 has been taken on a protest petition filed by the informant staff. Issue notice, returnable by 4 weeks. Record need to be called for here. Record.
Records, my Lord, that-
Yes, Lordship, here
Call for the-
in the order is reflected there is some materials against
Okay, call for the scanned copy of the record, trial court record, staff. List this matter after 4 weeks. When or when?
3 weeks, Lordship.
3 weeks, give date or what?
The second week of the Lordship, be it on 10, Lordship.
Hmm?
Be it on 10 of June, Lordship.
Okay.
10th of June, Lordship.
So there are two other private respondents, my Lord. Let it be after 4 weeks, my Lord. In the
4
meantime,
weeks.
we'll
Okay,
serve
4
notice.
weeks, staff, fair. In the meantime, okay, just a minute, sir. Where have you
The second
made averment that it was,
page
the-
103, Lordship. Page 103, Lordship.
what is that?
Order, Lordship. Order of the learned JMFC, Lordship.
Okay. Disclose ingredient.
Yes, that's it.
One paragraph, right? One paragraph. Then it is submitted that although the IO of the case has submitted final report into the case, however, the learned magistrate has taken cognizance of
Yes, ma'am.
of the case based on the protest petition filed by the informant, even without recording our satisfaction.
I've mentioned in para 7, page number 11, ma'am.
There are 7.
Ma'am.
Without recording disagreement with the police report. Okay. After that, issue notice. Huh? Okay. Then in the meantime, this will be they have already fixed.
Yes, Lordship.
What happened? It was fixed on February only.
Yes, Yes, my lord. But thereafter,
Then what happened?
we could not appear on the last occasion, my lord.
Huh.
So it has been fixed for evidence before charge only, my lord.
In that last sentence, taken cognizance of the case and went into fixing the matter for evidence before charge. Okay, then issue notice. Okay. In the meantime, it is provided that the proceeding of the GR, it's a GR case, GR number 8, 2025 arising out of Jang PS case number 2025 under section 318, 320, 335, 336, 340 of BNSL remain stayed till the next returnable date.
Grateful, ma'am.
Item number 8.
Yeah, please, my lord.
Yes.
Over here, the challenge is being made to the, my lord, impugn order, my lord, admitting the, my lord, second first appeal, my lord, and
Second first appeal.
second first appeal admission of the second first appeal by the, my lord, senior division, my lord, CGM Alo, my lord, senior division, my lord, Alo, my lord. And in the missed case, my lord, there is a stay of the, my lord, order dated, my lord, 13/3/2026.
Till this point, there is a stay.
Yes, my lord, there is a stay.
So today it is reserved for
Order, my lord.
the parties are appearing.
Yes, Lordship.
In the
Sole respondent, Lordship.
Okay, what is to be done today?
We are trying for disposal, Lordship. Lordship, here only law issues involved.
Okay,
So we are trying for the disposal, Lordship.
disposal. What is the,
My contention is that, my lord,
Hmm.
there cannot be, my lord, two first appeals, my lord.
just a minute, huh?
Two first appeals, my lord.
I thought parties are not appearing. So that is why. Whether record was called for?
Well, in fact, my lord, a record would not be necessary, my lord.
Not necessary.
At the base, my lord, here, my lord, the question of the law is to determine, my lord.
Okay.
In fact, my lord, if they raise the question of law, my lord, then they have to, my lord, clarify in a affidavit, my lord, that this is permissible under the law, my lord. That the two first appeal can be permissible under the law. That he has to.
Have you
show.
filed?
No,
You want?
no, Lordship. Lordship, here only to determine whether my Lordship knows there is a Arunachal Pradesh Civil Court Act. And that civil CPC is their central act. Lordship. Now, Lordship, when any suit, civil in nature, has been initiated under Arunachal Pradesh Civil Court Act, it has to be reserved entire provision. There is a prescribed provision also, is aware. First appeal, not appeal, first, second appeal, it's not mentioned, but the forum, Lordship, I also this section 15, only one section. which
Just a
says
minute.
that-
Then in that case, just a minute. Huh? So this is your is.
He will be arguing on the basis of the law of repugnancy.
Hmm.
Basic, no.
No,
His basic argument with the law of repugnancy
Mhm.
between the
So this was according to, it was a second first appeal.
second first.
The impugn order is second first appeal.
Second first appeal.
Earlier what happened?
My lord,
First
a
appeal.
Kebab incident was there, my lord.
Hmm?
A Kebab incident was there, my lord.
Hmm.
Against that, my lord, the petitioner has also filed an appeal before the, my lord, Interblaze Territorial.
So who lodged complaint first?
We was.
Before the
Keba.
Keba?
Yeah.
You lodged complaint
We
and
lodged
it
a
was decided in your favor.
No, my lord.
Okay.
It was not in my favor, my lord.
Okay.
That's why I filed the appeal before the, my lord.
It was against you. So
Against
you
me,
filed
my lord.
appeal before the
Appeal.
Civil Judge Senior Division?
No,
Hello?
no. Before the Interblaze
Okay.
Territorial Court
Okay.
appeal.
Hmm.
And thereafter, simultaneously, my lord, he has also filed an appeal
Okay. Before?
before the Interblaze Territorial Court.
Okay.
An appeal
Huh.
under section 15.
He was also agreed by the decision. Both were agreed. Okay.
Thereafter, the Interblaze Territorial Court
Hmm.
has passed an order
Hmm.
in an appeal.
Hmm.
Against that appellate order, decision of the appellate.
It was,
court.
the decision was in whose favor? By the appellate authority, Intervillage? Okay. Huh.
They filed an appeal
Huh.
for the district judge at Basar, which was subsequently withdrawn by them. And again, they have filed the first appeal before the senior division. Allow.
Okay.
To my respectful submission, that cannot be permissible under the law. Because second appeal,
There was a, when withdrawn, there was a liberty was granted to him.
liberty was granted to file
Okay.
before appropriate forum.
So the first appeal was before the Intervillage,
Yes.
and thereafter, this is second appeal.
Second appeal was filed
Huh.
for the senior division,
Okay.
which is not permissible under the law. Because
Okay.
second appeal is maintainable only before the Honorable High Court.
Yes.
Under section 100.
Hmm.
Read to section 101.
Yes, sir.
My contention is that. So, my lord, the senior division doesn't have jurisdiction to entertain the second appeal.
What the law says after the decision by the Intervillage Territorial Jurisdiction, the Intervillage Customary Court, where it next?
Appeal, there are, my respectful submission is that.
Hmm.
that
It's 15.
Enter territorial
Hmm.
village court has two jurisdictions. One is original jurisdiction
Hmm.
and another is appellate jurisdiction.
This was appellate.
This is appellate.
Hmm.
Against the appellate decision of a.
Let us see can we see the provision?
Yes.
15.3,
15.
15-4, no, 15-4.
15.4.
15-4, amended.
If agreed by the parties,
Yes.
shall lie before the Intervillage Territorial.
Please, सब चलन करते हो. Kindly see. Page 140 is the number.
provided that appeal against,
140 is the Arunachal Pradesh Civil Code Act 2021.
just a minute, yeah.
My lord will find. Initially, appeal lies under section 15, not to find at page 142.
Oh, you have annexed.
Kindly, I have annexed the, my lord, the act, my lord.
Hmm.
The Arunachal Pradesh Civil Code Act 2021, lords will find at page 104.
Yes.
The appeal, page
10,
140,
okay.
this is the unamended act, Arunachal Pradesh Civil Code Act 2021.
Yes.
Appeal provision kindly see at page 142, section 15,
Hmm.
appeals.
Yes.
Kindly come to my lord, page 143.
Yes.
Subsection 3,
Hmm.
my lord may skip and directly come to second provided matter.
Hmm.
May I get madam?
Yes.
Provided further that from the date of commencement of this act, in case an appeal is preferred against the judgment of customary court in the court of district judge or in the court of additional district judge, as the case may be. The court of district judge or the court of additional district judge may dispose of the same or proceed with the case de novo.
This was amended again.
This was amended, my lord, by my lord, Amendment Act, Arunachal Pradesh Civil Code Amendment Act 2022, lords will find at page 146.
Hmm. Yes.
My lord will come to directly, my lord, by this, my lord, by section 3 of
Hmm.
this Amendment Act,
Hmm.
they amended the provisions of the section 15, my lord,
Yes.
at page 147,
Hmm.
Roman 3.
Yes. Hmm.
May I read, my lord?
Yes. Hmm.
After the fourth provision, there were earlier only 3 provisions, my lord.
Mhm.
After the fourth proviso, to the section 3 of the section 15, the following subsections shall be inserted.
Hmm.
An appeal from the village authority,
Hmm.
if agreed to by the parties, shall lie before the inter-village territorial customary court or apex court by whatever name court.
Hmm.
Shall settle the case as per local tradition customary laws under the provision of the section 40 of the Assam Provincial Administration of Justice Regulation 1945.
Hmm.
In this matter, again matter, the first line matter, if agreed by the party,
Hmm.
second matter, omitted matter, deleted by an amendment made in the matter, Arunachal Pradesh regulation matter.
Hmm. If agreed by the parties have been amended, deleted.
If agreed to by the parties has been matter, deleted matter.
Okay.
By an amendment in the AFR matter, Assam Provincial Regulation, by section matter 12 of 2023 amendment. Act. I will come to that.
Just a minute.
Now-
Next, yes, next, proviso.
So, my lord, by this, my lord,
No, just proviso. Read the proviso of that 4.
second provider.
Huh.
Yes, provided that an appeal against the order of the inter-village territory court or apex customary court shall lie before the court of civil judge, senior division, the court of civil judge, senior division, the court of additional district judge, or the court of the district judge, as the case may be, as per their territorial and customary jurisdiction.
An appeal against the order of the inter-village territorial
Court or apex court.
apex court. This is,
Yes.
this
Yes.
is talking about the original jurisdiction.
Yeah, here is the crux lies. My interpretation is that, my lord,
Hmm.
because, my lord, the inter-village territorial court has both the original as well as the appellate jurisdiction.
Yes.
If any order
Hmm.
passed by the inter-village territorial court in a matter original jurisdiction,
Hmm.
then, my lord, appeal will lie before the civil court. My lord.
Hmm.
In my case, my lord, the first proviso will apply, my lord. Because, my lord, the appellate territorial court has passed the judgment, my lord,
Mhm.
against which they have filed the, my lord, appeal the first appeal before the senior division. Civil judge senior division. Which is to my respectful for submission not permissible matter. Because my lord, in the my lord, the civil court acts provides my lord, in the courts of the civil courts my lord, the CPC will be applicable. My lord.
Now, here in this Civil Code Act, after this, the appeal from the appellate authority is no more, is not mentioned.
Not mentioned. So my lord, as CPC is applicable for the civil courts my lord,
Mm-hmm.
the section 100 of the CPC will come into play. And second appeal will always lie before the High Court now. Well, before that, my lord, I will, my lord, kindly, my lord, why I am saying, my lord, the Inter-Village Territorial my lord Court has the original jurisdiction, my lord.
Let us come to 100, second appeal.
Manage the busy guidance. May I read, my lord?
Just a minute. Yes, please. Sir.
Appeal from appellate degree.
Mm-hmm. Yes.
Second appeal, save as otherwise expressly provided in the body of this court or by any other law for time being in force, and appeal shall lie to the High Court from every decree passed in an appeal by an court subordinate to the High Court if the appellate court is satisfied that the case involves a substantial question of law. So, my lord,
So this is to be decided.
yes,
And probably, I think,
yes,
you have any authority in this regard?
yes, my lord. My lord, first I have to complete that, my lord. The
Hmm.
Inter-Village Territorial Court has, my lord, two jurisdictions, my lord.
Yes, yes.
Because my lord, original as well as
Hmm.
the appellate jurisdiction.
Mm-hmm.
Now, my lord, kindly take up the, my lord, volume 1, my lord, code, my lord, for AFR, my lord.
Mm-hmm.
Section 36, my lord, may I read, my lord? Just I want to project that, my lord. The Inter-Village Territorial Court has two jurisdictions.
Hmm.
One is original jurisdiction and another is, my lord, appellate jurisdiction, my lord.
Hmm. Just a minute.
My lord, kindly note some sections, my lord.
Hmm.
Civil justice, may I read, my lord?
Please,
I,
Assam Frontier Regulation.
yes, my lord.
Which one?
Volume 1. Page will be 57, my lord, in my book, my lord. Section 36.
Just a minute.
May I read, my lord?
Page 57,
57 in my
civil proceedings.
civil proceeding, my lord.
Yes. Hmm.
Civil justice shall be administered by the blade authority.
Yes. Hmm.
Civil justice shall be administered by the blade authority.
Hmm.
Under this, my lord, Arunachal Assam Frontier Regulation of Justice, my lord.
Hmm.
Regulation, my lord. Otherwise, my lord, under the Arunachal Pradesh Civil Court Act, there are civil courts, my lord. Now, my lord, in the same book, my lord, kindly, my lord, there was section 2F, my lord, those you will find at page 57, my lord.
This is was amended.
51, my lord.
This is what amended latest. Or what?
Page 51,
23, sorry. Page 51.
page 51. Section 2. F.
Yes. Village authority.
Village authority
Hmm.
has been defined here,
Hmm.
means members of traditional village council or inter-village territorial council. My lord, section 36 speaks of village authority, my lord. Civil justice shall be administered by village authority, my lord. And village authority is being described here. Inter-village territorial council or apex council, my lord, by whatever name called, including the head Gaubura, head Gauburi, Gaubura, Gauburi, and traditional village head. Am I got it, my lord?
Yes.
By this definition, my lord, the inter-village territorial court has, my lord, the original jurisdiction also, my lord. And again, my lord, kindly, my lord, section 5(1) at page 152, my lord. Page 52, my lord.
Section?
5, my lord.
Hmm.
The appointment of the village authority, my lord. Section 5, may I read, my lord?
Mm-hmm.
1, my lord.
Hmm.
The deputy commissioner shall appoint such persons as he considers to be the members of the village authority person village or villages, and he may specify and may modify or cancel any such order of appointment and may dismiss any persons appointed. I will kindly bottom of the minor explanation, minor.
Hmm.
For the purpose of the section 5, village authority shall include members of traditional village council, inter-village.
Where do I find that?
Same page, my lord.
Hmm.
Explanation, my lord, after.
Okay, yes.
Explanation.
Mm-hmm.
For the purpose of the section 5, village authority shall include members of the traditional village council, inter-village territorial council, my lord, may I kindly note,
Mhm.
or apex council by whatever name called as defined in the clause F of the section 2. My lord has already seen the clause F of the section 2. And the head Gaubura, Gaubura, and Gauburi institutions. The members of the traditional village council or inter-village council or apex council shall be determined by the head Gaubura, head Gauburi, or Gauburi, and the traditional village head as per the traditional customary laws and the practices, and head Gauburi, Gauburi shall be appointed by the deputy commissioner of the village authority. As my lord, section 36 provides that, my lord, the village authority shall be administered by the village authority, my lord, under the AFR, my lord. So, my lord, inter-village territorial council of the court is a village authority having original jurisdiction, my lord. This has been further explained, my lord, in the, my lord, Arunachal Pradesh, my lord. Thereafter, I will come to section 40, my lord, of the state court, my lord. May I read, my lord?
40.
Yes, section 40, my lord. This is also important for the purpose of, my lord, showing that the village authority has the original jurisdiction. You'll find that page 58, my lord. May I read, my lord?
Section 40.
Section 49. The village authority shall try.
Page 48.
Page 58, my lord.
Oh, 58, sorry.
May I read, my lord?
Yes. No.
The village authority shall try all suits without limit or value in which both the parties are individual.
Yes.
State of Arunachal Pradesh.
Yes.
As because my lord has always seen, village authorities includes my lord, village territorial court also, my lord. So, my lord, I want to derive from this provisions, my lord, that the inter-territorial village court has, my lord, have the original jurisdiction actually. To further, my lord, guard this explanation of my lord, I will kindly, my lord, come to my lord, Arunachal Pradesh Civil Court Act, my lord, which I have annexed, my lord, in case 140, my lord. May I read, my lord? Case 140. In my
140? 40?
140.
Hmm. Yes,
May I read, my lord?
yes.
First, paragraph, same, my lord. May I read, my lord?
Hmm.
The following act, which was passed by the Arunachal Pradesh Legislative Assembly in the sixth session of the seventh Legislative Assembly and the received the assent of the Governor of Arunachal Pradesh. Now, kindly take note, madam. The assent of the Governor of Arunachal Pradesh is hereby published for the general information. Madam, why I make this submission, madam? Because my learned friend come up with the, madam, the principles of the law of recognition under Article 254 of the Constitution of India. My lord, my learned friend may come up with a plea of under recognition matter under Article 254 of the Constitution of India.
Hmm.
There is a provision, my lord, under 254 of the Constitution of India. If, my lord, even a act passed by the state legislation, my lord,
Hmm.
but having assent of the President of India, who will, my lord, have a force in the particular state, my lord.
Hmm.
In this case, my lord, this assent has been given by the Governor of Arunachal Pradesh, my lord. I want to show that, my lord, this act doesn't have the supremacy over the act, that is the civil procedure code, my lord, passed by the parliament, my lord. Under the, my lord, Article 254 of the Constitution of India. My lord, now come to, my lord, definitions, my lord.
Hmm.
Section 2, my lord.
Hmm.
Civil code has been defined, my lord.
Hmm.
This another Arunachal Pradesh Civil Code Act 2021. 2B, my lord. Civil code is being defined.
Hmm.
Civil code means a court of district judge, a court of additional district judge, a court of civil judge senior division, a court of civil judge junior division, or a customary court, my lord, my kindly note, my lord,
Hmm.
a customary court including village authority by whatever name the called upon under the Assam Frontier Administration of Justice 1945. And, my lord, the customary court has been further defined as D, my lord.
Hmm.
Provided D, my lord. Customary courts means court of traditional council or authority of the villages, individual to state of Arunachal state by whatever name called, includes the court of village authority under section 5 of the Assam Frontier Administration of Justice 1945. my lord. And, my lord, village authority has been defined under AFR, which includes, my lord, the inter-territorial village court, my lord. Now, my lord, then, my lord, come to, my lord, the classes of court, my lord. Section 3, my lord. Next page, my lord.
Just a minute, huh?
Chapter 2 of the State Act, my lord, under the Civil Court Act. Section 3, my lord.
Just a minute, huh? Hmm.
There you go.
Hmm.
Page 143, section 3. In
Yes.
addition to courts established under any other law for time being in force, There shall be established the following classes of the civil courts and the state. The court of decision, the court of additional decision, the court of civil judge senior division, the court of civil judge junior division, the customary court. And my lord, customary court has been defined, my lord, which includes, my lord, inter less territorial court, my lord. And my lord, then section 15, my lord. By all these sections, my lord, I think when I have convinced my lord that, my lord, the inter less territorial court has also the original jurisdiction, my lord. Then, my lord, the appellate jurisdiction, I will try to convince your lordship, my lord, at page and same back, my lord, 142, section 15, my lord. The provisions of appeal. And then I come to next page, my lord. Page 143, my lord. Subsection 3, proviso. Second proviso, my lord. Page 143, my lord. Subsection 3, second proviso, my lord. May I read, my lord?
Yes.
Provided that from the date of commencement of this act, in case an appeal is preferred against the judgment of the customary court. Customary court, my lord, is seen already, my lord. It includes, my lord, the village authority, inter-village territorial court also, my lord. In the court of district judge, my lord. Or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same or process with the case de novo. And initially, my lord, under the Civil Code Act, my lord, appeal from the, my lord, village authority shall lie only before the district judge or before the additional district judge. This was, my lord, amended by, my lord, Amendment Act of, my lord, Arunachal Pradesh Civil Code Amendment Act 2022, my lord, will find at page 146, my lord.
Twenty-two.
Yes, ma'am. And for the sake of the only appeal, my lord, I'm placing this, my lord, Amendment Act, my lord. By section 3, my lord, of this Amendment Act, my lord, the amendment of subsection 3 of section 15. By section 3 of the Amendment Act, amendment of the section 3, subsection 3 of section 15, my lord. Next page, my lord. After Roman 3, my lord. My lord, my lord, you have always seen, my lord. My lord, for sake of repetition, I will again repeat, my lord. 4, my lord. This 4 has been inserted, my lord. After the 4th provisions of the section 3 of the section 15, the following subsections shall be inserted. Appeal send and appeal from the blade authority, if agreed by the parties, my lord, may skip this, my lord, shall lie before the inter-village territorial customary court, my lord. What I want to project, my lord, is the, my lord, the appeal, the first appeal has been filed before the, my lord, civil judge senior division, my lord, which doesn't have the jurisdiction to entertain the second appeal, my lord. Because the inter-village territorial customary court will pass the order as a matter in an matter appellate in an appeal matter as a appellate court matter. And second proviso, my lord, this will be applicable, my lord, when, my lord, the inter-village territorial court passes an, my lord, decree in original site, my lord. And, my lord, also, my lord, can we see, my lord, if agreed by the parties which were omitted minor, file minor, amendment in the FIR, AFR minor, you should find at page 148. So this is mandatory in SR minor, page 143 at 149 minor.
Page?
And then page Roman 3 minor.
Page
149 minor.
one 49.
Minor, plus minus amended minor.
No, this is same.
So amendment, owner the, no,
This is same with the,
page 150 minor. The most.
there are two copies of the same act that appears.
Sorry, sir, answer minor.
Hmm.
Yes, madam. Page 150 minor, kind of, 150.
Hmm.
Section 13 minor, page 151 minor.
Instruction. This is 23 amendment, section 13.
Section 13 minor.
Just a
In
minute.
order for the Civil Code Act, in section 15, in subsection 4, for the words married again manner. In amendment of Arunachal Pradesh Civil Code Act, number section 7. Roman 1, in Arunachal Pradesh Civil Code Act, in section 15, in subsection 4, for the words, if agreed to by the party, the word if agreed by the party or if agreed by the party desires to appeal, as the case may be, shall be substituted. This if agreed by the parties has been minor omitted and it is substituted by
Agreed by
if
party.
agreed
or
to
if
by party or
party.
if agreed by parties desires to appeal, as the case may be, shall be substituted.
If the aggrieved party desire to appeal.
Or minor, if the aggrieved party desires to appeal. Minor. Here, minor, the aggrieved party will file the appeal before the minor. Civil justice seniority. Minor, for a moment, my lord, kindly see, my lord, his appeal before the my lord, Interplace Territorial Council, my lord. Page 1,
Just a
page
minute,
93, my lord.
Just a minute. If agreed by the parties, the word is agreed by the parties. Agreed by the parties. Okay, by this, if agreed by the party has been replaced by if aggrieved party desire to appeal. Okay, yes, then
It's a mandatory, my lord. Appeal provision, my lord. It's a very appeal, my lord.
no, it says if aggrieved party desires to.
Fine appeal.
Okay.
Accordingly, my lord,
Okay.
they are desire, my lord, they find the appeal, my lord. My lord, can we see the first appeal? Their application, my lord, appeal, my lord, the memo of appeal, my lord, before the Police Territorial Customary Court, madam. Page 93, madam. Page 92, madam.
Hmm.
Subject, madam.
Hmm.
An appeal under section 3, Roman 3, 4 of the Arunachal Pradesh Civil Codes Amendment Act 2022. It should be, madam, number section 15(4) of the, madam, Arunachal Pradesh Civil Code Amendment Act 2022. Against the impugn grade level Kebab Islam dated 16/7/2025. It's a first appeal, madam. And my lord, all along, my lord, he has been saying that it's a first appeal, my lord. My lord, because my two appeals were filed before the, my lord, interplace, my lord, territorial, my lord, court, my lord. Then they have approached this honorable court also, my lord. My lord has, my lord, kindly see, my lord, for a moment, my lord. Page 123, my lord, for clubbing these two appeals, my appeal and his appeal before the, my lord, interplace territorial court, my lord. Page 123, my lord.
Hmm. Yes.
May I read, my lord?
Yes.
So, my lord, order, my lord. May I read, my lord?
Yes.
We have two, my lord.
Hmm.
By filing this civil division petition under Article 227 of the Constitution of India, the petitioner has challenged the second parvana dated 21/9/2025 issued by Interplace Territorial Customary Court or Apex Customary Court, Pasar, in appeal preferred by the respondent against the Keba decision dated. In appeal manner, preferred by the respondent against the Keba decision dated 16/7/2025, passed by the Customary Court of Gorilla, Pasar, successors. 3. The contention of the petitioner is that being agreed by the order dated 16/7/2025, the Keba decision manner, both the petitioner and the sole respondents have preferred separate appeals before the interplace territorial customary court. It's a own admission manner that they have prepared and manner. First appeal before the manner, interplace territorial customary court manner. The grievance of the petitioner is the same that both the appeals prepared by the petitioner as well as the sole respondent are against the same Keba decision dated 16/7/2025. Therefore, the interplace territorial customary court or appeals customary court petitioner ought to have clubbed both the appeals together and taken up for hearing minor. Accordingly, minor has disposed of the minor at page 125, paragraph 8 minus. Accordingly, while not entering into the merit of the case, this civil petition is disposed of at a motion extend the interplace territorial customary court is directed to plan both the appeals preferred by the petitioner as well as respondent and proceed to hear and dispose of the same together in accordance with the law. Minor is also directed to dispose of the both the appeals manner by clubbing together. And accordingly, my lord, the interplace territorial council court has disposed of the appeal matter. Here, but others. Now, my lord, so my respectful submission is there, my lord. The interplace territorial court has two jurisdictions. I'm so my lord repeating that. As original as well as appellate jurisdiction. And the impugn order has been passed by the my lord, senior division my lord, in a second first appeal matter, which is not permissible under the law matter. And Thank you for section 100 provides, my lord, the provision for filing second appeal only before them under High Court. Here too, only on limited ground of substantial question of law, not other question. I reserve my right to reply after my colleague, my lord, submitted.
We are taking full-time hearing. Just a minute.
Yes, sir, after the submission, my lord, there may be requirement of the
Okay,
executive.
Uh, okay. Yes,
May I please, Lordship?
yes.
Lordship, the question before your Lordship is to determine whether the proceeding that has been initiated under Arunachal Pradesh Civil Code Act, after filing its first appeal, can it be switched to the provision under second CPC by filing second appeal under section 100? It has to be determined. What my senior has made a submission is that the Inter-Blaze Territorial Customary Court has two jurisdictions, original and affiliate, Lordship. Lordship, to that effect, Lordship, my Lordship has gone entire act, the definition where the Blaze Authority has been defined. There is no single words where it has been conferred a original and affiliate jurisdiction to the Inter-Blaze Territorial Customary Court. As my Lordship aware that there are two procedures for initiation of a civil cases, civil disputes in our state, Lordship. The first is Arunachal Pradesh Civil Court Act. Initially, it was, Lordship, the CPC, of course, Central Act. Then AFR Act 1945 regulation came, wherein, Lordship, as in under Section 5, the Blaze authorities was appointed by the Deputy Commissioner, Lordship. But in entire AFR regulation, Lordship, who is Blaze authority has not been defined. And the Gaubura system, Blaze command system, Lordship, that has not been defined. That is why, Lordship, by bringing this amendment, they have defined the members who shall preside over the customary court, command system, Lordship. May I take you to that definition, Lordship, once again, as my Lordship has gone. Lordship, this amendment, AFR amendment regulation 23, Lordship. AFR, it simply provides the Lordship under Section 5, the Deputy Commissioner will appoint the Blaze authorities of such number in such particular blazes, Lordship. And after that appointment, Lordship, they are discharging the jurisdiction of civil power under Section 36 and Section 40 of AFR, Lordship. They have unlimited jurisdiction in a civil dispute, Lordship. Now, Lordship, that after this enactment of the Civil Court Act, in initially also 2021 also, they not defined the legislature, they didn't define the Blaze authorities. Now this amendment was brought, Lordship, 2023, Assam Frontier Regulation, Administration of Justice Regulation. And definition is 2F, Lordship. 2F. May I read, Lordship? Blaze authority means members. Now, by this definition only, they provided that, Lordship, the members who will preside over the customary court and the Inter-Blaze Territorial Customary Court, Lordship. The Blaze authority means members of Traditional Blaze Council or Inter-Blaze Territorial Customary or Apex Court by whatever name called, including Head Gaubura, Head Gauburi, Gaubura, Gauburi, and Traditional Blaze Head. This definition, Lordship, it's nowhere mentioned that the Inter-Blaze Territorial Customary Court will have the original as well as the affiliate jurisdiction, Lordship. This definition only says who will preside over the Blaze authority, Customary Court and Inter-Blaze Territorial Customary Court, Lordship. It will the same members, Lordship. The Gauburis, which has been appointed by the Deputy Commissioner under Section 5 of AFR, Lordship, original AFR. This is the definition, Lordship. Now, Lordship, then Section 5 of Arunachal Pradesh Civil Court Act, Lordship. Lordship, one moment. Lordship, I'm sorry, same amendment, AFR, Lordship, Section 5. Section 5 was also amended. But the original, that definition regarding appointment was not amended, but explanation has been inserted, Lordship, by same amendment, Section 5, Lordship. Section 5. Here,
Yes.
Section 5, Clause 3 was inserted, but Clause 3, it says, again, Lordship, in AFR, there was no any rules and regulations prescribed for appointment of place authorities, Gaubura Buris. Therefore, this sub-clause 3 was inserted. Now, explanation, Lordship, may I read? For the purpose of Section 5, Blaze Authority Cell, now, Lordship, again, Blaze Authority Cell includes members of Traditional Blaze Council or Inter-Blaze Territorial Council or Effects Court by whatever name called as defined in Clause F of Section 2 that I have read earlier, Lordship, and Head Gaubura, Head Gauburi, Gauburi institutions. Now, Lordship, this explanation also says who will be the Blaze Authority, Lordship. These definitions are only who will be the Blaze Authority that appointed under Section 5, Lordship, and who will preside over the customary court, that is yes, as per Civil Court Act, customary court, and then Inter-Blaze Territorial Customary Court. Now, Lordship, even after enactment of Arunachal Pradesh Civil Court Act, Lordship, again, the provision for appeal, earlier it was in AFR, but that has been amended. Earlier, whatever, Lordship, any persons who agree the decision passed by the Blaze Authority, they have to file their appeal before the Additional Deputy Commissioner and the Deputy Commissioner. So it was amended by enactment of this Civil Court Act 2021. But again, Lordship, the appeal provision was not included. So they brought the amendment again in 2022, Lordship. Section 15 in original Act, Lordship, what I'm saying, in Section 15, they provided the provisions of appeal against the civil court, senior division, junior division, and then additional district judge and district judge. But the appeal against the order of Blaze Authority, that has not been.
Under the first Civil Court Act, Arunachal Pradesh Civil Court Act, I have already shown that Section 15. Initially, appeal from the Blaze Authority lies to the district judge and
Yes, yes.
additional district.
Hmm.
Was subsequently again amended. Based on
22, this is 23 and 21. 22. No? Okay, 22. Okay.
No, appeal against the Blaze. जुत्ता नहीं बोलेगा ना, हाँ, नहीं. May I read Section 15 once again, Lordship?
In which one? Amendment
This amendment lawsuit.
22,
Yes, lawsuit, 22 amendment, Civil Court Act.
section 15.
Yes.
Yes, amendment.
Yes, lawsuit. Here only lawsuit, the appeal against the order of the Blaze Authority, customary court. That has been provided where appeal has to be preferred lawsuit.
Hmm.
In original civil act lawsuit, this appeal against the other civil court has been provided, but the customary court that was not provided. Now lawsuit may I read section 15(4).
Hmm.
An appeal from the Blaze Authority, if agreed by the parties,
This has
this
been amended.
agreed and aggrieved that has already been shown by my senior lawsuit. That is
Hmm.
clear lawsuit. Now, the aggrieved party who desires to appeal, means this is now it's become a statutory appeal. Of course, the aggrieved party will definitely file for the appeal.
Hmm.
An appeal from the Blaze Authority, if agreed to by the parties, shall be before the Inter-Blaze Territorial Customary Court or Apex Customary Court by whatever name called, who shall settle the case as per the local traditional customary laws under the provisions of Section 40 of Assam Frontier Regulation Act. Now, lordship, the appeal. Here, lordship, unlike the CPC is provide first appeal, second appeal, but here in our Arunachal Pradesh Civil Court Act, it says only the aggrieved party shall file appeal against the order of Blaze authorities. Customary court shall before the Inter-Blaze Territorial Customary Court. Lordship. Now, provided lordship, provision, provided that an appeal against the order of the Inter-Blaze Territorial Court or Customary Court shall lie before the Court of Civil Judge Junior Division, the Court of Civil Judge Senior Division, the Courts of Additional District Judge, or the Court of District Judge, as the case may be, as per their territorial and pecuniary jurisdictions. Now, lordship, this act is very clear, lordship. First, we have to file appeal before the Inter-Blaze Territorial Customary Court. Then second, against the order of Inter-Blaze Territorial Customary Court, again we have to file appeal before Civil Judge Junior Division, Senior Division, then Additional District Judge and the District Judge.
No, where?
Lordship.
Can you read it again?
Yes. Provisional lordship.
Yes,
Yes.
provided.
Yes. Provided that an appeal against the order of
Order. It
Yes.
says order.
Yes. Order of Inter-Blaze Territorial Court or Customary Court shall lie before the Courts of Civil Judge Junior Division, the Court of Civil Judge Senior Division, the Court of Additional District Judge, or the Court of District Judge, as the case may be.
Now, this, you mean to say that this order is order in appeal before the inter-village territorial?
Lordship. Lordship, I'm not getting.
This an appeal against the order.
Yes.
This order, according to you, is the order passed by the inter-village territorial court in the appeal.
Yes. Yes. Yes, in the appeal. Because first provision provided that otherwise there is no forum for filing a original suit before the Inter-Blaze Territorial Customary
Okay, so that becomes this appeal before the inter-village territorial court would be a first appeal. Do you agree?
Yes.
Okay.
For the sake
Then
of counting the.
yes. And after, if the person is aggrieved, then this order of the appellate authority, that is the inter-village territorial court or territorial court, the appeal before the civil court would be second appeal,
Yes.
isn't it?
Yes, Lord.
Okay, then,
Yes.
so after second appeal, according to you, where lies?
According to me, as per Civil Court Act, Lordship,
Huh.
there is no provisions provided after the appeal against the second appeal, Lordship, before order passed by the civil judge. Then 227 application will be applicable, Lordship.
Okay, so that means after this first appeal, second appeal lies before the civil court.
Yes.
Sorry, civil judge senior division.
Yes.
Okay.
Junior.
Now, in your case, you have filed second appeal before the district judge,
Yes, Lordship.
withdrawn.
Yes.
That was withdrawn.
Yes,
And then now you file second appeal before?
before the civil judge senior division. It was filed, Lordship, it was filed before the district in session court,
Hmm.
Basar.
Hmm.
So accordingly, it was withdrawn with a liberty to file a fresh before the CJM, because in Basar, there was territorial issues because Lafarada district doesn't have civil judge.
Okay.
So therefore, it was only on the basis of the territorial jurisdiction. It was filed before the district in session court, Basar.
Okay.
But thereafter, it was withdrawn.
So,
It was filed before the civil judge senior division, Lordship.
hmm. So this is a first, second appeal,
Yes, Lordship.
according to you?
Yes, Lordship.
Okay. So how it becomes second appeal?
Lo-
According to you, it is a second appeal.
Second first appeal.
Oh, sorry, second, first appeal.
There cannot be second first appeal under the law.
No, this is, according to you, this is second appeal or first appeal before the civil judge?
Second appeal.
Second appeal.
First appeal was filed before the.
Yes, this is second appeal.
Yes, second appeal.
My submission is the second appeal lies only before the High Court. Under-
Not before the civil judge.
No, only before the High Court under.
Hmm. No, so that is why I'm asking. This says, the proviso says that provided that an appeal against the order of the Inter-Village Territorial Court or apex customary court shall lie before the court of civil judge. So this, according to you, is against the order of the Inter-Village Territorial passed in the
Passed
original
In
jurisdiction,
the original jurisdiction matter,
not in the
not in a.
order, not against the order passed in the appellate
Yes.
as an appellate jurisdiction. Now,
That's why I'm.
the
saying
second appeal is only before the High
High
Court,
Court.
not before
not
the
before-
civil judge, And this is talking, this proviso is talking about the appeal passed by the Inter-Village Territory in the original jurisdiction.
Yes,
Okay, so now this is to be
this is to be.
clarified.
determined.
Hmm.
If my lord, he says that my lord, that by virtue
Now-
of the my lord,
Hmm.
the act passed by the state legislature, my lord,
Hmm.
the amendment act, my lord, Arunachal Pradesh Civil Code Amendment Act, shall have the supremacy over the my lord, and the act passed by the parliament. my lord.
Now, you have to satisfy that this is not the appeal filed by you is before the civil judge lies, and we need to know now, you have to satisfy that second appeal before the civil judge. It lies before the civil judge, not before the High Court. You have to satisfy.
Yes, Lord.
And also satisfy that the appeal which this as per this proviso says that the against the order
Yes.
lies before the civil court is not against the order in the original site by the Inter-Village Territorial. You have to satisfy the court.
Lordship.
Lordship,
Lordship, that issue, Lordship.
Affidavit, my lord.
So I think you need to file yes in this case. So
If my lordship may
Ah.
allow,
because
lordship, I may be allowed to make my submission. Lordship,
Because this will have an immense repercussion.
well, that is why.
no, Lordship, there is a misunderstanding of the provisions of law, Lordship. What happened, Lordship? Two provisions of laws are clubbing together, Lordship. That is why, Lordship says, suppose, if in my earlier submission, I have made submission that, Lordship, two provisions for initiation of the civil dispute, Lordship. If I initiated my civil dispute under civil court, CPC, Lordship, of course, there's under section 9, say suppose it is land dispute, civil suit has to be filed, title suit has to be filed. Then against that order, section 96, first appeal, Lordship. Then section 100, second appeal. This is the provision under CPC, Lordship. Now, Lordship, when I have initiated my proceedings under Arunachal Pradesh Civil Court Act, now can it be possible to say that after filing a first appeal before the interblessed territorial customary court, I can directly switch to the provisions under CPC, Lordship? Both acts are not complementary and not supplementary.
Now
to
you
each
have to
other.
satisfy that the second appeal, there is also second appeal provision under the CPC or under the Arunachal Pradesh Civil Code Act before the civil court.
Lordship,
You have to satisfy that.
Lordship.
Earlier, my lord, before.
Lordship, the provisions is
One by
very
one,
clear, Lordship.
one by one. No.
Before, my lord, my lord, the Arunachal Pradesh Civil Court Act came into force, my lord. The Arunachal Pradesh, my lord, Assam Frontier Regulation Act was applicable, my lord. There were provisions for appeal against the village authority.
Before this year. Mm.
To extend commissioner
Yes, yes.
and the deputy.
As per the pecuniary jurisdiction. Mm.
This has been done away, my lord.
Mhm.
Amended, my lord, by the AFR Amendment Act 2022, my lord, and the Civil Court Act, my lord. These provisions, the appeal provision has been done away, my lord. That's why, my lord, Arunachal Pradesh Civil Court Act by section 15, it was inserted, appeal provision was again inserted, my lord. Again, the decision of the village authority. Initially, my lord, by under the unamended act, my lord, it was before the district judge and the additional district judge. Subsequently, it was again amended in according to the territorial jurisdiction and the pecuniary jurisdiction.
So according to you, do you agree or that the inter-village territorial customary court has a original jurisdiction also?
No, Lordship, no.
It doesn't have.
No, no, only affiliate jurisdiction. Only affiliate. That is, they are the affiliate authority against the order of this authority, Lordship.
What if any dispute arise between the two villages? Where it will go? Mm.
That is where, Lordship, interblase is constituted. Whatever, Lordship,
Where they will file? Mm.
Lordship,
Where they will file?
there is a circle-wise, Lordship. The villages, entire villages has been in my community, especially in Galo side, Lordship.
Mm.
We have a circle-wise villages, having 5-6 villages. The interblase territorial customary court, the Gauguras of that combined village circles, they will sit as a interblase territorial customary court. That is why under
That is original?
no,
jurisdiction?
affiliate,
Appellate.
affiliate.
No, my query is, what if
Interblase.
inter-village dispute arises?
Yes.
A dispute arises between two villages. Where the original jurisdiction lies?
Yes, if
Who will decide?
in case interblase dispute, Lordship,
Ah.
then the entire villages, Lordship, that governing both the parties,
Bango,
Bango.
Yes, exactly. It was earlier called.
It was earlier.
Bogumboka.
Bogomboka.
Yes.
Bogumboka. Now it has been called as a inter-village territorial court.
So the Bogomboka also entertain
Yes,
the
earlier, Bogumboka entertained the inter-village.
inter-village, that is original side.
Yes. Is there a dispute between people?
I think you have to satisfy. Probably you may have to file affidavit to this.
The intent matter has to become in an affidavit.
Yes, because it is not clear that it is order of the appeal order, appellate order, or the order of the original. So that is why you have to come in affidavit form.
Lordship, that's why it is clearly says that appeal from the village authority shall file before the interblase, then order from the interblase shall be civil. Means he's an affiliate authority because he has taken the cognizance of the appeal that has been filed against the decision of village authority. Also.
This order is order of the appellate court or order of the original.
No, Lordship, affiliate.
So that you have to, I think you have to come with the affidavit.
In clause 4, Lordship,
Yes,
an appeal from the village authority,
yes.
if agreed by the parties, shall lie before the interblase. Lordship means
That is, yes,
Yeah.
right before intervillage.
yes, I have filed before the interblase first
Uh-huh.
against the decision of village authority. Then on my appeal, Lordship, they has passed an order, Lordship. Therefore, I have filed a appeal before the civil court, Lordship.
So that amounts to second appeal otherwise.
Here,
If that interpretation goes,
if,
that amounts to
if-
second appeal, and then the second appeal, it's giving power to the civil judge,
Then-
according to him.
that's why law of recognition will come into force.
Yes.
Article 250.
Mhm. So that cannot, okay.
The state aid cannot override the act of the parliament.
You come with the affidavit. We'll take this matter up next week,
Lordship, Monday,
Monday,
yes.
okay?
In the
Mm.
meantime, I will-
Mr. Okay, hard, Mr. R. Sakya, Lana Senior Counsel, as he said by Mr. I. Lana Counsel for the petitioner. Also had Mr. Lawley, Lana Counsel appearing on behalf of the respondent who submitted the, who wants to file affidavit, in response, Stop. Let's pray for, this matter next Monday. Okay, 25. 25. Act. Yeah.
Item number 9,
May I please, Lordship? Lordship, this is anticipatory bail. Lordship, on 10/4/2026,
Yes.
may I please, Lordship? Lordship, on 10/4/2026, have been granted an interim bail with a direction that the accused petitioner shall have to appear before the IO within 10 days. So, Lordship, accordingly, I have appeared on 20, and thereafter I have been served with someone to appear on 21, then 22, and 23. I have continuously interrogated on 4th consecutive date, and thereafter bail bond was executed, and bail bond amount of 50,000 was already deposited in the account provided by the respondent GST authority. So, Lordship, I am cooperating with the investigation. And
Yes.
Uh,
What remains?
Yes, may I, Lordship?
Yeah.
So here, actually, through this investigating officer, the
Hmm.
affidavit with objection, written objection, it's been filed.
Mhm.
So, Lordship, here, this person, the alleged accused, he is a professional syndicate who is handling around 6 fake firms. And he has created a fake document in the name of one Srimati D. Degu of this Pasigat. And he forged the document, and he had established Gagan Infra Service firm in Arunachal Pradesh. And based on that, he has issued, this alleged accused has issued more than 5,649 fake ITC. And that amounting to 150 crore if tax evasion of this government. Out of this 100 crore 57 lakhs, 50% taxes of this government of Arunachal Pradesh and 50% is a central government. So apart from this Gagan Infratech case, apart from this, there are 5 more cases against him. He is a professional handler, and through investigation, it has been revealed. It's there in page number 56, Lordship, as per our written objection.
You have filed written objection also?
Yes, yes. 55, where A, that's page number 55. Because everything is on record and it's on digital form. And that person has been evading this investigation for this September.
Page 55?
55, yes, 55. A, that
No, it's, and at,
MS Gagan
ends
Infra.
at 51. Thereafter, no more
Yes.
pages.
So here,
No, 55 page, okay,
that bulky.
what is this thing?
Lordship, that bulky one.
Okay, this market.
Yes, that.
Yes,
Yes, Lordship, after investigation, it has been revealed that MS Gagan Infra Services, it's registered in the state of Arunachal Pradesh with the GST number, is a fake non-existing entity, having shown its principal place of business located at 41 Rowing Electrical Subdivision, Mayu. Even they had the forged document of electrical department also. And here, this is the address they had shown. And based on this, the investigating officer has visited and examined the dango, the person that agreement is there in this. This agreement is there in 76, Lordship. Based on this address.
page 76.
Yes, page 76. Rent agreement. 76. Yes. Here, they had made one, this Srimati D. Dangu as the owner of that rent, and Gagan Infratech as another party to show and to register their office over here. And based on this document, they had established a firm, that Gagan Infra Service. So based on this, only in this case, this Gagan Infratech fake firm, they had 22 crore. And they had issued numbers of fake ITC. This is a one case. This is a one case. And based on this case only, the initial.
How 22 crore?
It's there on record, Lordship. I will. It's in written objection also. Because there are 6 fake firms, and totaling those 6 firms, it's 106 crore. So categorically, this those amount has been segregated in page number 64, that fake ITC. It's 22 crore is there in page number from 67, paragraph 25. That record has we reveal that records have been revealed through written filing of this GSTR 1 and GSTR 3B, where means those whoever is running a business with a GST number, page number 67, paragraph number 25, Lordship.
Yes.
Yes. Paragraph number 25. From the investigation conducted so far, Sri Jayanta Bhattacharya found to be actively involved in filing GSTR 1 returns in respect of the above 6 fake firms. That's MS Gagan Infra. So instant anticipatory bail is regarding the Gagan Infra. For remaining, that case are still pending. This MS Varun Infra, that case is still pending. MS Aditi Enterprise is also still pending investigation. MS Vidant Trading is also still pending. MS Kumar Enterprise is also still pending, and MS DR Enterprise in the state of Arunachal. All these 6 firms has been registered in the state of Arunachal Pradesh. And that has been recorded through that person, that this Jayanta, he was holding all the passport, filing the returns, and even he has hacked one of the bank account of this one, Sanjit Murshid. It's there in page number 58. Through that bank account, his filing. And after investigation, officer has come to know that this person doesn't know, he's a poor person, illiterate person. And his account has been used to file the return and to pay the amount for return.
Whose account?
That's one Mr. Surjit Murshid. That's in page number 58, Lordship. That person's detail. In last paragraph, upon further 58, page number 58, upon further verification, it is found that the payment of late fee was made from the bank account registered in the name of person, namely Sri Sanjit Murjit. Account number, mobile number, and his other address is 8 Dayal Mitra Lane, Vedan Street, Kolkata. After this, the IO has visited this person and examined, and they had found that he doesn't know about those things because his bank account has been used by this alleged accused. And all the return allegation will be dragged, investigation will be dragged into this Sujit, that account holder. But after examination, it has found that all the record, all the transaction, all the bank details, and all the password of this 6 firm, GST login ID, income tax return ID, all record are with this person, and that has been seized by the IO. Now, after that case initial investigation that has come, almost initial stage was done in the month of October, November 2025. From then onwards, this person is evading and not cooperating the investigation. So that's everything was on digital record, Lordship. And this seizure Panchnama is there in Annexer C regarding this seizure and Panchnama and everything. It's on record. And seizure, this Annexer C is 83, page number 83 to 90.
What seizure? What it shows?
Uh,
What was seized?
Seized all the document regarding this pen drive and the password where means all those 6 firms detail. Firms detail, because to file a return, that person need to do means log in the ID, and subsequently there is a requirement for cross OTP. And this cross OTP number is also being handled by this person for this six firm. Therefore,
Well, where have you stated that the generally 6 form?
it's there in Lordship. It's in page 55 only. From there means this second paragraph by operating this fake form. And even the paragraph number 9, it's in page number 57, Lordship. All the detail about this one-time OTP return filing, all the details are there in this paragraph number 9, page number 57. Where this late fee has been filed for this in 6 occasions. 57, 58, all the details that has been reflected in this objection, written objection. page number, paragraph 9 and 10, that's about the, how this investigation has initiated.
Where is the FIR? Let's see once.
Lordship, here in this, especially in GST case,
Hmm,
there is no concept called FIR.
Okay.
There is a concept called alert,
Where?
where means based on the digital record,
Mhm.
they issue summon. So that based on that, this person has all the credential record. So therefore, the summon has been issued to this person to answer the justify their involvement in this case.
Okay.
So especially in GST, it's a digital generated account because they had the user has created account over there with a GST number. So through that account only all the official notification and everything and communication were done. And it's also that service is also recognized as per the CGST law. It's there in CGST section 159, where means this registered through registered account number that summon and service and everything notification need to be served.
Now that his statement has already been recorded,
Lordship, here actually he has not cooperating the investigation because there is a need of further record because he's over there in Kolkata. So it's very difficult.
he appeared before the IO.
Yes, on this stipulated period, last day only, 20. Because he was supposed to appear within 10 days.
Hmm.
That's so 10 to within 20. But he appeared on 20 and 21. And according to, as per this record and the submission communication with the IO, investigating officer and SP. So there are remaining record he need to be submitted because there are some document and credential has been seized, but that need to be authenticated by him. But he is not cooperating in that part. Therefore, the custody is required for further interrogation because it's not about only this one case. It's about remaining 5 cases are pending. So total 6 cases, Lordship. And the instant AB is regarding only 1 case. So he is a habitual, Lordship, habitual offender in this digital offense. So that's the fair submission as per the record submitted by the IO of this case. And IO has filed this affidavit in opposition with the bail objection on record. So that's the reason all the transaction, the detailed record, all are there. That's the affidavit in opposition is bulkier than the bail, anticipatory bail.
So his anticipated bail should be rejected
Yes, that's
because it is bulky.
yes. No, Lordship. It's not about that. It's about the evasion of this economic revenue of this. State
What is the
government.
punishment prescribed? by the
It's
way?
a 5 years.
5 years.
Section 132.
Where do we find? Where is the section?
It's in
In your,
CGST, Lordship.
Hmm?
It's in CGST.
No, where in your?
It's there in law.
In the-
It's there. It's it's in page number 53 and paragraph 4. Page number 53, paragraph 4.
Hmm.
May I read?
Yes.
Sri Jayanta Bhattacharya being the accused in connection with his involvement in issuance of fake input tax credit and issuance of fake invoice under the firm, namely MS Gagan Infra Service, has been arrested on 22/04/2026. That's based on the interim. Under section 69 of CGST Act 2017 for offense of GST evasion under section 132, 1 clause B and C. That's issuing and availing of fact input tax credit of the CGST, punishable under section 132 L and Roman 1, which is cognizable and non-bailable under the provision of section 132 clause 5 as per the arrest authorization dated 2204. This is the means compliance being done by us, but specifically section 132, and it's a highest punishment. There is not more than 5 years. That's the highest punishment. Where means if someone has evaded more than 5 crore, then it's a non-bailable, cognizable, and 5 years. If prosecution has been launched, then it's a 5 years. Because here two type of means prosecution. One is for recovery.
When the summon was issued?
The summon, it's there in 91, page number 91, Lordship. (29/10/2025), 29 September of 2025. It's a part of procedure as per the section 70 of CGST Act.
So after receiving this summons, he approached this court.
No, Lordship. After receiving this, again, this authority has issued summon. Again, next page in next.
So here, on 29 October, he did not appear.
Yes, he didn't appear. In all the occasion, he didn't appear. So that's the reason means he was apprehending that he might be arrested. But verbally, because there is a Lordship procedure. If suppose the person is from West Bengal, then if suppose officer from here, if they wanted to do the search, seizure, and arrest, then they need the permission from the commissioner of the West Bengal for CGST. So that is a procedure. So during that procedure, most of the cases that alleged accused have been informed or they are aware about the case. So that's the reason they usually escape from that search, seizure, and arrest. So officer has visited in many occasions to this Kolkata in his locality. From then onwards, so after that only in the month of this April only they filed this pre-arrest bail application. So from September till March, after receiving this summon also, he was evading the investigation. Just he need to tender the document and everything. Just it's on digital report.
So the investigation is still going on.
Yes. Because he is the person, because there is no other person. He is the only person who has all the credential record. And he knows everything. Until unless custody, because as a part of investigation, there is a need of custody.
What is the procedure after completion of investigation?
After completion of investigation, Lordship, there is one thing is that if suppose this amount is clear, then so-called notice will be issued to recover that amount from their account and for the attachment of property. That's one part. And
Attachment of property of whom?
this whoever may be found to be
Okay,
the person involved in this.
okay, the farm.
Yes. For example, this person is involved in this case and the account transaction and everything is on record. Then this property attachment.
No, what action with regards to the account of the petition has been taken by the investigating agency?
Lordship?
Till now, what steps have been taken?
That's why there is a procedure because it's a investigation part is quasi civil in nature, especially in this CGST.
Okay.
So here means it's a preponderance of probability. Where means till date, the officer is not in that situation to seize or freeze their account until unless his statement has been subscribed properly. And all that seized document and the credential has been authenticated. So for that, that person need for this further interrogation.
But he is not appearing.
Yes.
He
So
appeared how many times?
after
Till date?
this interim, he appeared on 2 occasions, according to their this additional affidavit,
Fourth occasion.
or 4 occasions.
20
Okay.
20 to 23, I've been continuously summoned
Ah.
and I have feared.
Who else? Any other accused also here in this case, apart from the present applicant?
Actually, Lordship, actually, there might be a group of syndicate,
Okay.
but still, till date, all the telephonic record,
Hmm.
bank record, and the login ID for 6 firm, not only for 1 firm, for 6 firm is with him, and he's filing the return. And by using someone's bank account, and also created a fake rent agreement and document, fake electricity bill, just to register this firm. That's in Arunachal Pradesh. Almost same type of one case is also there in one more case is there. So here, Lordship, after that, the so-called there is a secondary part is a prosecution launch, where means for prosecution process will be that's for criminal part. That's only for this one 5 years punishment area. So there are 2 areas. So till that, officer cannot seize or freeze those things. Because it's an initial stage, Lordship. If you see this, Lordship, see the summon also. And after receiving summon, he's evading.
Someone was issued on 25, okay. October.
May I please, Lord?
Yes, please.
Lordship, that's why if, as per the record only, that's my fair submission only, Lordship. Apart from that, if my friend, he would like to submit, then he may.
Okay.
May I please, Lordship?
Yes.
Lordship, in this case, the first summon was issued on 29/10/2025.
Mhm.
I have been directed to FER. I have also enclosed my summon and except 2 of my AV application, Lordship. It is the same summons on by my learned friend.
92.
Yes, 20.
Phase, yes, Lordship. Phase number 20. In fact, what if the brief fact, Lordship, I am serving as a chartered accountant in this present firm, MS Gagan Infra Services. So my duty was only to file GST return and any other works that has been directed by the firm, forfeiture, Lordship. Now, accordingly, Lordship, the summon was issued to the forfeitor on 25/11/2024 also, page number 19, Lordship. 19.
Page
19. 19 of my application, bail application.
what? Okay. What is this?
This is summon, Lordship.
Hmm.
Issued to the farm forfeitor farm.
This was in the way back in year 24.
Yes, Lordship. Yes. Then next page number 22. This was the summon issued to me in my name, Lordship.
Hmm.
It was issued on 29, Lordship, 10, and I have been directed to appear on the same day. So accordingly, I appeared, Lordship. And thereafter, Lordship, I appeared on 2nd 11 also before the CGST authority, Calcutta. The summon was also directed me to appear before the authority at Calcutta. So on 2 occasions, consecutive occasions, I have been interrogated. Thereafter, Lordship, the GST authority, they ran after the accused petitioner, Lordship. Despite of appearance, Lordship, accordingly, Lordship, who have filed, the accused petitioner filed this bail application before this honorable court. And accordingly, Lordship, on 10/4, it was directed the accused petitioner to appear before the authority within 10 days. As my learned friend tried to project it that I appeared on last day only, it's not like that, Lordship. Since I'm residing at Calcutta, order was passed on 10, but CTC was furnished on 11. So it has to be communicated to the applicant So accordingly, he appeared on 20. Thereafter, he was interrogated continuously for 4 consecutive days, Lordship. Now, Lordship, in this case, my learned friend has made a submission that since it is an offense on the digital records, that entire records had been seized by the authority. They have enclosed the mentioning the pen drive also. So, Lordship, here my respectful submission would be, Lordship, my custodial interrogation is not required. And in their bail objection also, they doesn't show any that circumstances which shows that my custodial interrogation is required. Lordship, I am cooperating. Whatever information they asked, I have already furnished. In fact, they have seized the entire digital documents, Lordship. It has to be investigation to be through the digital records only, Lordship. That I have been complied, that they have already seized. In fact, they have enclosed many documents which is not in my knowledge, Lordship. And regarding the procedure, Lordship, to add provisions, as my learned friends has submitted, that in GST offense, the section 73, 74, 74A notice has to be issued. Accordingly, this notice was issued, Lordship. Now, thereafter, Lordship, I have to file reply as per their allegations. Now, before your Lordship is the allegations only that I have committed this fraud, that the amount has been cheated. That is their allegation. That has to be ascertained through investigation, Lordship. For that, I am appearing, I am cooperating, Lordship. Now, after filing my reply, Lordship, if the GST authority not satisfied, then do a demand. And forfeiture of my properties, Lordship. Then there is a provisions of first appeal before the commissioner's appeal. That is under section 107. Then thereafter, there is a provision of second appeal. And then third appeal before the Honorable High Court. And thereafter, Lordship, the order has to be challenged before the FX Court, Lordship. So entire provisions for recovery, if assuming, Lordship, I have committed the allegations that has been asserted by the authority, there is a provisions to establish through the proper investigation. And for that, Lordship, I am cooperating with the investigation, Lordship.
So where do I find the status report of the investigation?
Lordship,
And then the remarks of the
it's
person who investigating?
Lordship, it will be the statement. Statement will be in the actually on last occasion. Actually, we have not sought for the status, but just to submit their means a statement only. That was the reason. Means I had not asked for the status.
No, we need to
even
say that the case, the progress of the case and what more is required and what is his opinion, whether the custodial interrogation is required or not.
Lordship, here actually for clarity, actually, according to this page number 19 of their bail application, initially this notice was issued against their firm. Subsequently, after examination of all the detail record and transaction, and IO investigating officer has found that there is a filing of return and everything from one mobile number and through one bank account. Then based on that, this officer has cross-examined and visited that person and investigated the bank.
Just a minute, this is an objection.
Yes,
Isn't
yes,
it?
yes,
Yours?
Lordship.
So just you obtain an instruction
Yes.
regarding the letters,
Okay.
the status of the case, okay? And his comment also.
Okay,
What is the progress?
okay.
What is now and the present status and his comment, whether for what purpose he is in custodial interrogation, because he has already recorded the statement till now twice.
Lordship.
Okay. Add Mr. Lord, Counsel for that. petitioner, also Mr. Keeper, who filed affidavit in opposition on behalf of the respondent. However, Mr. Keeper submits that the status of the present status of the case, status of the investigation is not furnished to him. Therefore, pray for some time to produce the status of the investigation of the case. The present status of the investigation of the case, staff. Case prayed for. Come and list this matter on Monday. When?
Monday will also do, or
Hmm?
Tuesday,
Next
because
Monday?
Tuesday, Lordship.
Tuesday is the DB day.
Then Wednesday.
Then Wednesday. Okay.
Lordship,
Wednesday.
27 is holiday, Lordship.
Oh, 27 holiday.
7 holiday.
Hmm. Then 28. No, 28 DB lodge. No. 28 is the DB there. 22
today is
this week only. 22.
Lordship not on 22, on then Monday will do it.
Monday.
Because if some other matters before you go for arguments and also there maybe had some hectic. This,
Okay.
no, item 8,
Then,
8 was fixed on Monday.
Day after tomorrow, 21.
Possible.
I will
22.
21 possible.
22 this Friday.
22, Lordship. I'm sorry,
Right.
Lordship, I have free occupied.
even I have
Okay. Then
25, 25 Monday.
Hindi ko minamit ito.
Yeah.
Hindi ka ito meeting.
Okay, 29 then, Lordship. Or
Let it be on 29,
29.
Lordship.
Hmm?
29.
28 also, I will, it's okay for me. 28.
Okay.
29,
29.
29.
29.
highly aware.
Item number 10,
Lordship, interim order, maybe.
The interim order passed earlier shall continue till then. Okay.
Deeply obliged.
May it please your lordship.
Yes.
On last occasions, it was
Lordship,
called for lordship. Petitioner
Lordship.
number 1 was granted interim lordship.
Lordship, here, Lordship, the statement was not been recorded, Lordship. So today I have spoken to IO, Lordship, that today they will record the victim statement. So Lordship, then it will be listed again on Wednesday, Lordship, day after tomorrow.
After tomorrow.
No, lordship, can it be on lordship 25 lordship? I have some difficulty, lordship.
Okay.
25 lordship.
Statement recorded. He was directed to appear before the eye of the case.
Lordship, I approached the IO lordship on
Hmm.
13 and 16 lordship, the petitioner number 1 lordship.
Hmm.
But due to some unavoidable circumstances, lordship, they could not take my statement,
Okay.
lordship.
Heard Mr.
P. Board, lordship.
Clerk Counsel for the petitioner who submits, Mr. Also heard Miss El Hagelan Edison PP, Stop, Mr. Borua. Clerk Counsel for the petitioner submits that although she appeared, otherwise appeared.
Petitioner number 1 appeared before the IO.
How many petitioners are there?
2 petitioner lordship.
In the one bail application, why?
2 petitioner lordship. Both are
Why?
relative lordship.
Both are?
Relative lordship.
So what? The conditions and the they are relatives. Why in one petition?
Lordship, actually, what has happened?
Condition if the one is a main accused, another is not a main accused.
No, they
have
are
the
not
condi-
main accused, lordship. The one Azizur Islam was arrested, lordship. And the petitioner number 1 is the wife of that Azizur Islam. And petitioner number
Why you have filed this anticipated bail for 2 person in the one bail application?
2% lordship, both they are relative. And
So
on
what? So what?
last occasion, lordship,
Supposing one is a main accused, one is not a main accused.
lordship,
And then if condition put against the one person,
lordship,
they will go against the other also.
lordship. Lordship, in this case, only one was granted the interim, lordship, not 2, lordship.
Why you should create confusion in that way in one bail application?
Lordship,
What's the difficulties in filing 2 bail applications for each?
lordship, since they are relative, lordship, and they are issued summons a notice
In
under
the, in the
35
criminal
issued
case,
to
how
them on the same
how
day,
it counts?
lordship.
Huh? Relative cannot be separated.
Lordship, they can be separated, lordship.
Hmm.
Only one was granted interim, Lordship, on the last occasion.
And that too, Lordship, because the condition was that Lordship, that lactating mother, Lordship. That's why Lordship, one day only given Lordship for the appearance and to submit her statement. Because the Bancor Lordship, the statement could not be recorded. So IO has said that today they will record the statement of the accused Lordship.
Who is it? Which one?
Miss
Petitioner
Fatima
number one.
Khatun, one Lordship.
And the other one?
Other one Lordship, the interim was not granted Lordship.
Make it simple,
Lordship.
one by one.
Lordship.
See, one granted, other not granted. And then a record how it goes.
Order also Lordship, only for petitioner, one Lordship, this is reflected Lordship. Two is not reflected.
Hmm? You want to save the court stamp or what?
Lordship, no, Lordship.
आइए तो petition file करें, ये file another petition.
CDR में तो dispose ही हो जाएगा मतलब.
What about the other accused? Will he or she?
He, Lordship.
Lordship, CD also Lordship for one also only Lordship we have called because Lordship in the order only one this petitioner one Lordship for that only the order has been passed Lordship. Yeah, Lordship for petition number 2 there's nothing whisper Lordship about this one.
May I submit one thing, Lordship? Lordship, CD may be called for Lordship and in
It was called for.
Lordship. And because CD will be one Lordship. In the meantime, one will.
In the CD, nothing about regarding the other accused.
No Lordship.
So-
So dear Lordship, IO also Lordship, he was Lordship only for one Lordship they have made the this.
No, when case diary is called for, it should be entire case diary.
Entire case, Lordship.
Okay, Mr.
Keyboard
Lana Counsel for the Lana Counsel for the petition submission. Although the accused appeared before the IO of the case
On 13 and 16.
on 13 and 16. However, his statement could not be recorded by the police, and therefore, due to some difficulties on the part of the
Lordship.
accused applicant.
Not accused applicant, difficulty on part of their.
Okay, could not be recorded. Therefore,
Lordship.
under the circumstances. No, in view of the above, Miss, you are also praying.
Yes, Lordship. Lordship,
Okay.
then Lordship, it should be reflected that the CD may be Lordship for the petition number 2
Okay.
also. Lordship, it will be reflected Lordship because Lordship as per
Miss
the
Lage
order
also
Lordship, there's no Lordship reflecting on the
press for granting. How many days you said?
Lordship. Actually, Lordship, day after tomorrow Lordship,
Okay.
I can produce Lordship, but he is
Lordship,
No,
having some
no.
difficulty.
So you said that his statement would be recorded.
Lordship.
Yes, Lordship, the petition number 1 statement will be
When?
recorded today Lordship
Okay,
as per the IO
Okay.
statement Lordship.
as for the IO's comment, the statement of the accused will be recorded today. Therefore,
Lordship.
praise for listing this matter again on
25th.
Wednesday,
25th.
for me
25th,
Lordship,
Lordship. I
Wednesday,
have some
but
difficulty.
if he is
Okay.
having difficulty, then
Okay.
25.
25.
In view of the above, and as prayed for, come and list this matter again on 25.
Lordship, then
On which date the Line Edition PP shall produce the entire case diary.
Yes.
Okay, case diary would be a scan copy or
Scan copy Lordship,
scan copy of the
because AV
Yes.
Lordship. Yes.
entire case diary. Stop, huh? Then,
interim order will be continued.
till then, the
Only
interim
one Lordship,
order passed earlier shall continue
only for petition number 1 Lordship.
in respect of the petition number 1.
Yes, Lordship.
Okay. Okay.
Obliged, Lordship.
Obliged, Lordship.
Item number 11.
May it please your Lordship.
Yes.
Lordship, today it was fixed for issues and documentation, Lordship. However, the documents are not ready, Lordship. So may I pray that this matter may be listed on 28th?
28.
Yes, Lordship. Lordship would be here as per the roster.
Why? Let us list it on some other day. Before that,
Lordship, the issue is earlier also it was fixed for issues and documentation. Issues are ready. However, documentation part, some of the documents are to be
On the-
obtained
on the
from the
next
office
page.
of the returning officer. If I could not get hold of the documents which have been annexed in the election petition, I'll make appropriate
28 is a
application.
DB day, it will be difficult.
Then, since it is documentation and issues, Lordship, it
Huh.
can be taken up on 29 also, Lordship. The only certain documents are there, not
Okay,
much,
okay, 28, will, 28 in the afternoon at 2
Lordship,
after
Lordship.
DB,
Lordship.
okay? We'll fix
Since-
it. Hmm.
Some of the documents are at the office of the returning officer, so
Hmm.
that has not been furnished to the petitioner so far.
Hard, Mr. Milani Council for the election petitioner. Also hard, Mr. Deori, Lanet Council for the
Sole respondent, ma'am.
sole respondent return candidate. Stava, Para. Lanet Council for the election petitioner. Some states the praise for further week time to prepare the document. Submits that although the issues are ready, the documents are yet to be arranged. Therefore, pray for further 1 week time, to which Mr. Deori Council for the respondent return candidate has no objection. Prayer allowed. It's agreed upon by the parties. This is matter again on 28.
28.
Okay.
Complied.
Deeply aware.
Item number 12.
My lord, that in this case, my lord, we have filed the application for striking out of the pleading by way of IA 214, my lord.
You have an objection?
My lord, they have filed the objection.
Objection, okay.
And also, we have also filed another IA at 240, my lord,
Hmm.
for amendment of the WS, my lord. So, may I
Amendment.
pray, my lord?
Hmm.
Can this matter be fixed on 21, my lord? Thursday, my lord.
21.
Yes, my lord.
Thursday is a DB day.
With the,
Oh.
we can, my lord. My lord, we can see.
Lordship, if my learned senior agrees, then it can be fixed on 22nd. Because in the meantime, I'll be filing the reply.
Let us take up the
20
on 22nd because this IA probably would take time, both the IA.
Lordship, yes.
Okay.
Only, my lord, actually this, the matter was represented by the senior counsel.
Okay, when he is coming?
Jumdar, my lord.
Okay.
So as per his convenient, only the 21, he's becoming.
21.
Yes, my lord.
21 is DB day.
DB day.
And DB day, we do not know.
Lordship,
How long it will take, we do not
My
know.
lord, that,
He probably is coming for DB. And if the argument take place, it might take long time, then we may not have enough time.
my lord.
Lordship, since this IA 214, even before this court, this matter was, Lordship is aware that was before some other bench, Lordship. So 214 was fixed for hearing. Thereafter, this matter was not listed. So in fact,
Fixed
it
for
is
hearing on
physical-
what?
The hearing on striking out of the pleading, certain pleading which is not relevant to the
Okay.
case, but that is to be strike out. What has to be strike out or not, that
Hmm.
the point, that on that point, my lord, hearing will be taken. But we have
Yeah.
filed a.
Hearing will, I think,
Yes,
that
ma'am.
hearing will take time.
That hearing, it required a hearing.
Lordship, physical presence of senior counsel may not be required because on the other occasion also, I went down all the way to principal bench. For-
Madam, that is
There is
different thing, madam.
there is an observation also by the earlier presiding judge
Yes, yes.
that it requires physical presence
But that is, it is convenient matter for, because the hearing is physical.
because it's virtual election
Virtual is-
petition is not possible.
Sometimes it's disrupted matter.
Hmm.
Sometimes Lordship, since Lordship is aware, this election petition has to be expeditiously disposed.
Yeah, that is what I'm saying.
Yes, then Lordship, 22nd Lordship, if not then since 214, some of the matters, same related issues has already been disposed of by this court in two IAs. One IA is 215 and IA 65.
That IA was for what?
That was basically IA 65 there was allegation that election petitioner was not physically present while
No,
filing. The
That was
Minor,
altogether
minor.
different aspect.
This will take time.
Yes, and
Striking off.
2-1 and Lordship 2-1.
And they have also filed objection.
My lord, they have filed objection.
Okay,
And
then it will
only
take time. It will take-
240 they have to file, my lord.
Lordship,
IA 240.
240 is for
They
what?
have not, that is the seeking leave for amendment of the WS, my lord.
See, amendment of the WS also.
My lord.
Lordship,
And
that,
you must be having an objection to that.
My lord,
Lordship, that issue has already been settled by the Honorable FX Court also.
that's
Since
See,
there,
see, then you see.
the Lordship, the
That-
same issue, two issue, Lordship, it may Lordship,
Mm.
two issues. In IA 65,
Mm.
the allegation was that the election petition was not present personally by the election petitioner.
Mm.
And the signature appended in the election petition was not that of the election petitioner. That was the number one issue in IA 65.
Mm.
And IA 215, IA 215, the extra copies of the election petition was not
215 is also not available there.
Yes, IA 215, extra copies of the election petition was not furnished to the registry, Lordship. That was the issue.
Mm.
So that both the issues in 215, they have,
This what we'll do,
my lord,
we'll fix it on, okay, 28.
my lord.
Lordship,
28 election, what we'll do, we'll get the less matter fixed because this will take time.
My lord.
Mm.
Lordship,
28.
Lordship, 240 would also take time. So Lordship, on 21st or on 22nd, Lordship,
Hmm.
let if the learned senior counsel, if he can submit his part, then on the subsequent day, I can submit my part, Lordship, if there is paucity of time.
On which date?
On 21st, Lordship, although there is DB, so it can be taken out on 25. Let the senior counsel, submit his part, and thereafter on the subsequent date on 28th, I can submit my part with regards to IA 215, Lordship. If
On that day,
I mean,
we
if-
can see the convenient of that, my lord, convenience we can fix.
21.
21.
21, and on particular on that, my lord, if there's a certain, my lord, development, we may take time, my lord.
Okay, on the, okay, hard, huh? Both, huh? And counsel for the election petitioner, huh? And Mr. Tabum, line counsel for the respondent return candidate, staff, para. On the on being agreed by both the line counsel for the parties, let this matter be listed on 21st. Okay,
My lord,
For Lordship,
at two.
my lord.
Lordship may kindly make an observation that IA number 214,
Well, that will-
5 may be heard.
At
Because
that time, we'll see it, my
Let
lord.
us- Because,
Lordship,
because during the pendency of that, we may not be able to proceed.
Lordship, that is there, but on the earlier occasion, since there was no specific observation made by this honorable court, the matter could not be
We
taken
can
up.
talk out at that point of when it's.
For
taken up.
hearing of IA
For
215,
hearing.
of IA 214, Lordship.
On IA 214.
Yes.
Okay,
Lordship. Deeply obliged.
Item number 13,
Met with
yes.
Lordship, this CRP is challenging the impugn Gabang summon issued by the President and Secretary of the Bangor Gabang Lordship without authority and jurisdiction. Now, counter affidavit is yet to file by the sole respondent also.
Are you filing?
yes,
Have you filed?
no, till,
Okay, when are you filing?
1 week, Your
Okay, are you, Mr.? Your good name was?
The loaner.
Okay, sorry. Lauren, non-counsel for the Petitioner, Mr.
T Tagu,
T. Tagu,
respondent.
Learned Counsel for the respondent. Respondent number?
Sole respondent.
Sole respondent. Praise for father. How much time you said?
1 week.
Father, 1 week time to file affidavit in opposition. To which Learned Counsel for the petitioner has no objection. Prayer allowed. Please this matter after a week.
After it.
Okay.
Interim order.
The interim order passed earlier shall continue till the next date of listing. Okay.
Obliged.
Much. Matter number 14.
Your Lordship,
Your Lordship, item number, IA number 214 was an application for adjournment. Since it was fixed on 28/05, so this can be disposed of.
Okay. I 214.
Yes, 214.
Okay.
And
This was adjournment of the case on 28/5.
28, yes, it was not taken up.
Hmm?
That was fixed, but it was not taken up.
Fixed on which date?
28/05.
28/05. Have we? It has not yet come.
No, Your Lordship, it was on 26/08/2025.
26/08/2025. Okay, we can dispose of.
Yes,
Okay.
this can be disposed of. Then I filed an IA 155. This is for striking of some unnecessary and frivolous documents, which they have annexed in their annexure.
Have you filed objection to this?
This morning I received the copy, not this morning, Malad. This afternoon, Malad, I have received the copy. I'm sorry, Malad, I may not be able to, Malad, receive the copy or not some other day.
They have filed the objection.
IA 14 dispose, huh? In view of the subsequent,
Lordship, we, as per the record, we have already filed that objections to 155, Malad.
Yes.
IA 155.
IA 14, just, in IA 14, huh? Subsequently, thereafter, some date.
Malad, what happened is, in this case, Malad, the Lordship, Mitali has taken up the matter, Malad. After this, Malad, it was not listed for a month, Malad, for long months together.
Okay.
Now it has been, Malad, came to know from the, Malad, the records that this has been transferred to your Lordship. So, Malad, on so many occasions, Malad, the matter was listed, but then, Malad, to that extent, Malad, the IA 55, Malad, for striking
Just
of
a
the...
minute. This 214 will dispose of, huh?
Yeah.
Hard both, huh? Who is the applicant here? 214?
Return candidate, it's me, Your Lordship.
Okay. Both the Learned Counsel for the applicant and the respondents are present. This is an application file under order 17 of the Code of Civil Procedure 1908 for seeking adjournment for the matter on 29/8/2025. Since in view of the, it was
not taken up.
Okay. In view of the, subsequently it was fixed only.
Yes,
Okay.
thereafter, no,
Okay,
this matter.
This application, just simple say, huh? This application has become infructuous, huh? Accordingly, stands disposed of. Okay? Deeply over. This is disposed, and then
IA
155 is in 155.
Yes, filed by me for striking up some. Yes.
And then you have filed any objection to
Yes,
this?
Malad. As per the records, we have already filed, Malad.
Okay, then where?
I have received it. And today, Your Lordship, I have filed one more IA.
No. Let us deal with this 155 first.
Yes.
So what order need to be passed here? An objection has been filed.
It will, detailed hearing needs to be done, Your Lord.
Okay.
Like the previous one.
In 15, huh?
Yes.
Malad, may I pray in item number, Malad, the IE 155, Malad.
155, sir.
Yes, Malad. In that, Malad, we have already raised the objection, Malad. That may be fixed shortly so that, Malad, it can be expedited. It's because
Okay,
we have
so-
already filed on the, as per the
What
observation of
else?
this.
What else? This and another application which need to be heard, which one?
It's, and
This
I,
IE.
Then what we'll do? Okay, so, hard, huh? Mister, who is applicant here? 155,
return candidate,
return candidate, hard,
yes,
Mr.
respondent in the election petition.
Okay. Learning counsel for the applicant, also Mr. M. Kato for the learning counsel for the respondent petitioner, huh? Staff, huh? The affidavit, sorry, the respondent stroke election petitioner has filed objection and the applicant return candidate has received the copy, receive and acknowledge, receive the copy and acknowledge, receive and acknowledge the, acknowledge the receipt of the copy of the applicant's person, huh? Staff, huh? On the request of both the learning counsel for the party, let this matter be listed on, this will be listed on 28.
Malad, 28 will be too late, Malad.
Because others fixed,
Subject to your lordship's convenience.
20,
On
28 will
20,
do.
on 25, Malad.
Because,
On 25, Malad.
25, some other matter already fixed.
Well,
That is
28.
why. 25 also can be,
It's 25 would be better, your lords.
25, okay.
25 is Monday, Malad, no division.
Okay, okay.
Yes, and along with, I have filed today one IA, your lordship, IA number
So
one.
what is this 211?
211.
211.
200.
It must be today's IA, your lordship. I have filed one IA, bringing on some documents that will suffice 155.
This is also adjournment.
Yes, Malad.
And then this 211 also, this hardboard, huh? Which is submitted, this interlocutory application has become infructuous. In view of the above, this interlocutory application stand closed. Okay, disposed of, huh? And then 55, what else?
Today I filed one IA.
Any today's filing?
Midnight.
IA not yet, not listed, it appears.
Yes.
Not listed, Malad.
Okay, then Mr. Whose name, huh? You're for return candidate.
Yes.
Okay. Learning counsel for the return, respondent return candidate submitted. Today he has filed one interlocutory application for what is this
Bringing
application?
some documents
Bring,
that will help up in deciding 155, IA 155.
that is in IA 155.
Yes, I have brought up some documents that will help while deciding IA 155, your lordship. Those are documents. which
Bringing on some documents for in connection with the IA
155.
155 2025, which is not on record, huh? Staff, huh? List, this is list a matter again on 25 along with the IA filed by the respondent today. Okay.
No, Malad, in main petition, Malad, it is at the stage of
That
Malad.
is in main only because it's main what?
In the main petition, Malad, it is at the stage of my lord, filing issues and documentation, my lord.
Okay, then this will be incorporated in the main, in main, right, Mr. M. Kato, non-counsel for the election petitioner, and Mr. Non-counsel for the sole respondent, return candidate staff, So in the main, what order need to be passed?
My lord, for next date, my lord, it is issues and documentation, my lord.
So then so many things in the, then on the next date.
Your Lordship,
My lord, admittedly, my lord, the IA has to be decided first. Then after, my lord, the issue and
Yeah.
documentations will come, my lord.
Okay.
Yes.
So, my lord, because
It is submitted that this matter is pending for issues and documents. Okay,
yes, my lord.
okay. And Mr. Land Council for the respondent submits earlier one, that today he has filed one IA to bring on record, to bring on some document on record in connection with the IA 155/2025. However, the same is not on record today. Stop. List this matter along with the IAs
On to the people.
On 25th. Okay.
Deep.
Okay. So then 25, no more matter, Okay.
Well, deep.
Item number 15.
Yes.
If I may. Your Honor, this is an IA 256. It's been pending since October 2025, Your Honor.
What is this matter? IA
For
about?
condonation, Your Honor.
Oh, condonation.
Yes, Your Honor. For
Yeah, Mr.
490
Jamo.
days.
How many days? Condonation or in filing?
490 days, Your Honor.
Filing CRP,
Your Honor.
490 days. You have objection?
Yes, my lord, I have already filed my objection.
File objection?
Yes.
Okay.
And it seems the respondent number one, they are not appearing in this particular case, even after effective notice, Your Honor.
Yes.
And they have appeared, Your Honor.
Who,
twice.
just a minute. CRP. This is IA. Respondent number?
One,
One is respondent.
Your Honor.
Just a minute,
They marked their first appearance on 18th December, Your Honor. Thereafter, they appeared on 30th of April, Your Honor. And today still they are absent, Your Honor. So on the last occasion, on 7th of May, the Honorable Court had given them a last opportunity. That is today, Your Honor. So I would request this Honorable Court to dispose of with this IA, Your Honor.
Just a minute. Just, what was the Keba decision?
Your Honor.
Just a minute, you have not this one. There is no index.
Your Honor, this is an IA, Your Honor.
No, just, I just would like to see what, in what matter it was decided. Right. It's very difficult to find unless you properly file the index with page number and all, na? There, you should,
It is in the
it
main.
takes
Your-
time.
Main.
That is in the main. In the main, you should, there is no index showing the page number.
There,
Because judges get time when? Get time only in the court, just to see quickly where is the page number and the document.
Your Honor, it is given in the main also, Your Honor.
Where?
The front page, Your Honor.
Page number?
The front page, Your Honor. First page.
Okay. Where?
No, the index of the IA. No index in the IA, only in the main here. This is main here.
No, it's IA. In IA also.
Oh, IA, no.
Yes. In main also.
Okay.
Yes, IA is. Index is there. I have received a copy.
Okay. It was decided in 2019.
Your Honor.
Just wanted to see the date, na?
Your Honor.
Okay. So this was,
Basically, Your Honor, in this, if I may just give a brief, Your Honor. Basically, this is a case, especially the IA, with respect to the impugn order dated 11/6/2024, Your Honor. Decision
impugn
was
order is
11/6/2024, Your Honor.
24.
Your Honor. Basically, in this particular order, Your Honor, the lower court below had upheld the Keba decisions, Your Honor.
Keba decision.
Yes, Your Honor.
That there was no,
Your Honor.
okay.
And the
No
reason,
discrepancy.
reasons which were given was adverse position.
No, okay. This order was passed on 11 June 2024.
Your Honor.
So,
If we can, it was passed on 11/6/2024. And if we may just go to page number 5 of the IA, Your Honor, para 6. I have explained the delay. Para 6, Your Honor. Page 4 is the para 6 and the explanation is at para 5 or page 5, Your Honor.
Page 5?
Your Honor. Is the explanation is a table given in table, Your Honor. Basically, on 11/06/24, decision was passed by the lower court below upholding the Keba decision. A reason given being adverse position. Thereafter, I filed a review application within limitation of 30 days. That is on 3/7/24. There are 3/7/24. And it was decided on 7.
Review before?
The same court.
Keba.
No. The lower court, CGM.
Trial court.
Your Honor.
Okay.
Technically speaking, the appellate forum, Your Honor.
Hmm.
Thereafter, it decided the review on 7 January 25. And in the meantime, this much delay had happened. Thereafter, Your Honor, being of limited knowledge, Your Honor, I filed and second appeal in district court. Within 30 days, there is the review was dismissed on 7/1/25. I filed an second appeal with limited knowledge on 4/2/25 with a condonation application. And then again, it was decided on 9/9/25. And this much amount of delay had happened, and it was decided that this particular second appeal is not maintainable at district court. It has to be filed in High Court, second appeal under section 100. And during this pendency and waiting for the certified copies, totaling 217 and 28 days had lapsed. Accordingly, after this calculation, this particular I is with respect to this 490 days. I'm explaining my delay, Your Honor. And accordingly, I have come with this condonation of delay application and this CRP to be admitted, Your Honor. So if this IA is decided today, Your Honor, we can proceed towards the CRP, Your Honor.
Yes, Mr. Jamo.
Yes,
My
Lord.
objection is on what?
my lord, very briefly, my lord, I want to explain my position in this objection, my lord. I am for respondent number 2. Respondent number 1 is the seller of the land. To me, respondent number.
Okay.
My lord, the brief background history is, my lord, since 1988, I purchased the land from respondent number 1. And in the year 2019 only, this applicant, they came up with the first kabang in the year 2019, more than after 30 years. There the kabang decided in my favor. Thereafter, a subsequent kabang was again called up by this applicant. Then also, I was, it was decided in my favor. I was in the peaceful position for the last 30 years, till 2019. Now it has been more than 30 years.
Now it is also
So,
under.
yes, thereafter they filed, thereafter, after in challenging the kabang decision, they filed appeal in the jurisdiction of the Civil Just Senior Division. Their appeal was dismissed. Appeal was dismissed and a review was filed. Review was also dismissed and in our favor, given in my favor. Thereafter, in the meantime, after the review, they went into as a second appeal, they went into the forum of district judge. Therein also,
second appeal should have been in before the High Court.
no, there is no option under the Arunachal Pradesh Civil Court that second appeal, because original jurisdiction was with the customary court, village authorities.
Okay.
So on that ground, under the maintainability, their second appeal was not maintainable. So now they have come in by way of this civil revision petition. So my lord, they have claimed an effective delay of 57 days. Now,
490.
total 490 days, and they, after subtraction of so many days, they've come to 57 days. My lord, if we can, in their, their annexure, my lord, I take your lordship to district judge judgment, that is on 9/9/2025, that is annexure 838, page number 35. My lord has got it?
Yes.
Page number 35, annexure 83. My lord, here also, on the third paragraph, just below the order, Mr. Alik Taro appears for the applicant, Mr. Denjing Sonal, so and so. Nobody appears for respondent number, this one. My lord, here my lord may kindly see, the present IA has been filed under section 5 of the limitation in 1960 for condoning a delay of 177 days in filing the second appeal registered at PSG, so and so. My lord, here also, there was a delay of 177 days.
Yeah.
Before filing this second appeal. There was this delay has not been reflected in this IA, that the instant IA. That time also there was a delay of 177 days. Furthermore, my lord, I'll take your lordship back to the paragraph 4 of their IA, the specific pleading. Kindly see at para 4. Page 3. Page number 3.
Hmm.
There, the council has himself submitted that under merit,
Yes.
and para 4, that thereafter, under a bona fide belief and due to limited legal knowledge, the petitioner preferred second appeal before the learned district court Pasigat on such and such date. My lord, whether the ignorance of a law can be a ground for condemnation of delay. Here the council himself has admitted, although bona fide, but due to limited legal knowledge, can it be a sufficient ground? That is one of my contention of objecting this condonation of delay. More so, my lord, thereafter, this petitioner, who is the main petitioner, who is about 85 years, has been duly represented by his power of attorney holder, who has also shown this affidavit also. All these rounds of series of
He has
litigation.
troubled you.
Yes, that is in a to show that there's no sufficient cause, my lord. These are some of the grounds. More so that after subtracting all these delays of and coming to 57 days also, that delay has not been sufficiently explained by the applicant. So
Anyway, so what we can do is, Mr. Jamo,
my lord,
what we can do at the moment is that, because ultimately he is not going to be satisfied with those, even if this court reject also, probably he want to trouble you. So what we can do at this stage is you pay 20,000 fine, because you have trouble. Here also it appears that you have filed and then let him spend money.
my lord,
Hmm.
my lord, may I submit?
Yes.
My lord, allowing this petition cannot be allowed in the manner because there's another title suit pending in the lower court. That has also not been.
What title suit?
There's a title suit on
In
the same
connection with
subject matter between the same parties. My lord, these are all disputed question of facts.
In connection with this?
Yes, my lord.
Same
So
land.
in the garb of a second appeal, the CRP cannot be allowed. That will be my submission, another submission, my lord. There's a title suit pending, which has not been brought to knowledge of this honorable court.
No, the title suit
on the same matter, same party, same subject matter, on the same land.
Where?
Pasigat District Court.
It automatically it will be dismissed.
My lord, they have not brought this knowledge before this honorable court. Brought this fact. I mean.
Judicata.
There's a title suit pending, my lord. This is a specific submission in my objection petition, my lord. Title suit number. My lord, may kindly take up my objection petition. My lord, I have specifically mentioned in para 11. Same subject matter, same parties.
If I may, Honor.
Paragraph 11 of my objection petition. Civil Just Senior Division, it is pending, my lord. Pasigat title suit number 8 of 2019.
If I may.
My lord, may consider all these materials.
You must have filed your objection there also.
My lord.
Have you already filed there?
No, they have not filed anything, Your Honor. If I may, Your Honor.
This fact has not been brought into the knowledge of this.
Is it a fact?
Your Honor.
Is it a fact?
Your Honor, if I may, Your Honor. My learned friend is, maybe he has not gone through the this thing, Your Honor, the IA properly, and he is yet to fully understand this particular facts of this particular case, in my opinion, Your Honor. Because, Your Honor, he submits that I had filed in condonation of delay application there at district court of 177 days. You know, this particular paragraph 6 and page number 5, it specifically includes all those delays, Your Honor. 277,
See,
217
bona fide, see, supposing if you, during pendency of this, also if you have filed a suit against the same party or regarding this or same property
No, Your Honor.
between the same party, within the same subject.
Yes, my lord.
Same party, but not same subject, Your Honor. This particular CRP has been filed against a sale deed written by hand in a plain paper in 1988.
Then, if that,
Which was only for 4 pura of land, Your Honor. 4 pura of land, Your Honor. And the suit that is pending there at Pasigat Court is completely different, Your Honor.
because
That's for
if that is correct, if that allegation is correct, it appears that your only intention is to trouble.
me, Your Honor. No, Your Honor.
If that is correct, what
No,
I'm
no.
saying.
No, Your Honor.
If that is not correct, then you have to clarify, it appears.
That is
Your
our
Honor.
submission.
Your
my lord.
Honor.
It is just a vexatious and harassment petition. All this series of litigation, this even that Kaba decision has attained finality. So in the garb of
Now,
second
in
appeal, we cannot allow
every
this
stage
civil
you have
litigation
been
petition.
making delay and thereafter file in the before the trial court also, you file for the review also.
Your Honor.
Review has been in our favor. It has been dismissed.
No, delay,
Review was also filed.
delay, there was a delay in filing review also.
That is
No,
not in my knowledge.
No, Your Honor.
No, what?
No delay. It can be seen in page
It's on,
number 5, Your Honor. I've given the
No, this was in civil second appeal, okay. For filing second appeal.
Yes.
because, Your Honor.
Before filing the second
Okay,
appeal also
second appeal was just filed and that is also after delay.
of 177 days.
Thereby cause unnecessary trouble.
My lord, even if we for the sake of argument, had the second appeal was maintainable, there also there was a delay in filing that second appeal of 177 days.
Your Honor.
No, this shows something which the court will not appreciate.
No, Your Honor. If I may, Your Honor. If I may, Your Honor. The review was filed, Your Honor, with respect to the main impugn order, that is 11/6/24, Your Honor. So it was going to, and it was going to adjudication, Your Honor.
The respondent number 2 submits the
Once a matter is admitted and it is going on and it is being heard, until and unless the final order regarding the review is decided, Your Honor, I still have sufficient reasons, Your Honor, to reflect, to file an IA in the district court itself, Your Honor. It's a separate thing, Your Honor. That second appeal was not maintainable ultimately. And it was disposed of on 7.
No, that was unnecessary. That second appeal filing before the district judge was
Your Honor,
unnecessary.
that I fully, Your Honor, bow down to. Your Honor, with respect is that the respect regarding this particular point is that, Your Honor, I still in our district, Your Honor, regarding the application of APCC Act and the second appeal, even this morning there was a matter going on with respect to that. It was very enlightening to hear the submissions of the rivaling councils, Your Honor. Still this confusion is going on, Your Honor. And my second appeal was registered at 02. Earlier, there was another second appeal which was registered and it was decided and a order was passed for admission, Your Honor. Since we are practicing out there, Your Honor, we go through the day-to-day hearing and accordingly, Your Honor, out of bona fide, we had filed a second appeal, Your Honor. Within limitation, Your Honor, including annexing an IA, Your Honor, or 177 days, Your Honor. This 177 days is reflected as 217 out here, Your Honor. 188 days, Your Honor. 10 days with respect to 177 days minus 188 days, 10 days with respect to the CTCs, Your Honor. So I have given a total rounding up of 188 days, Your Honor. And I am counting from 11/6/24 till the filing of this CRP 14/10/25, Your Honor. So totaling around 490 days. I clearly mentioned it in para 6, Your Honor. And Your Honor, I being a old age person, Your Honor, totaling around with almost 90 years, Your Honor, now. I am filing this CRP, Your Honor, with respect that this honorable court has a supervisory jurisdiction against the lower court when certain things are not done as per law, Your Honor. In this particular finding of impugned judgment 11/6/24, Your Honor, if we may just go to that order, Your Honor, and final judgment, Your Honor. It's in page A1, Your Honor, in page number 9 of the IA, Your Honor. If I may, Your Honor. It says that it is held that there has been no violation of principle of natural justice. There is no infirmity in the decision dated this, which is just and reasonable, and the same upheld as it is based on principle of adverse position. Your Honor, there are numerous numbers of authorities, Your Honor. A KEBA decision cannot decide adverse position, Your Honor. For adverse position, we need to go to a proper trial, proper examinations, and the disputing document of 1988. It has to be verified. They had just shown a plain paper of 1988, and accordingly a decision was arrived at KEBA decision, Your Honor. And this was mechanically upheld on 11/6/24, Your Honor, without going through the veracity of verification, trial, cross-examination of the witnesses, the document. It was just upheld like that, adverse position. So I request this honorable court that my IA of 490 days be condoned, Your Honor, as per section 5, Your Honor, because I have shown more than sufficient reasons, Your Honor.
No, no. Yet there is trouble.
Your Honor, if the honorable court can
Had Mr. Talo, learning counsel for the applicant. Also had Mr. Jamo, learning counsel for the respondent number 2. 1 or 2?
Respondent number 2.
2.
My lord, I think respondent number 1 is not interested to pursue.
None appears on behalf of the respondent number 2. Respondent number 2 is the one who sold you.
No, right now I am the possessor. Yes, I am the purchaser.
No, no. Respondent number 1 is one.
The one who sold me in the year 1988.
And then he is claiming on what basis?
Your Honor, I am claiming on
My lord, that is the matter, is one of the issue in the title suit.
No, no. What you are claiming the?
He is claiming the entire area.
Yes, sir.
In 2000, Your Honor, there was a KEBA decision which I decided in my favor, Your Honor.
2000.
Your Honor, Rani Bande KEBA.
No, he was also party there.
Yes, the opposite respondent number was a party on the.
No, no. Respondent number 2.
Your Honor.
2
No,
was
no,
also party
respondent
there.
number 2 was never a party to that particular case. The person who sold to him was the party.
In
And
my
he is
favor,
not appearing.
2019, both the Kabang is in my favor. 2019. They have
19.
never referred this 2000 Kabang also.
And your KEBA decided in your
2000.
favor is in the year
2000.
2000.
Yes, 19 years back. It was decided in my favor, same area. But they came with a document, piece of document in 2019. And it is
sold in which year? You purchased in which
We
year?
didn't call the Kaba, my lord. All these Kaba were called.
No,
by
no,
the
you
applicant.
purchased the
1988.
88.
Yes, my.
This is disputed.
Since then, I have been in peaceful possession.
Okay.
If I
Only
can
in the
just-
year 2019,
None
the
appear-
dispute was.
None represented on behalf of the respondent number 1, although the service complete.
Your Honor, complete. It's completed.
The service.
If the honorable court can just go to the list of document, Your Honor. List of dates, Your Honor.
Where?
Of the main, in the main, Your Honor. List of dates, sir. In the main petition, Your Honor, of the CRP.
To see,
It is clearly mentioned here, Your Honor.
what?
In
What
the
is
list,
mentioned?
List of dates, Your Honor.
List of that?
Main petition, Your Honor. After the synopsis, Your Honor. These are the documents, Your Honor. These are the list of dates and events, Your Honor.
No,
On
no, that is not correct.
10/9/2000, Cabao decided in my favor, Your Honor. So in this CRP, I'm only requesting for a de novo trial, Your Honor, nothing else, Your Honor. Because on 11/6/2024, Your Honor, limitation was disputed.
Where do we find in that the steps notice upon the respondent number 1 complete?
Steps lap on respondent number.
My lord, they've appeared
They've
in
appeared-
some of the occasions.
Okay,
Last occasion also, I think they took the adjournment.
okay.
They took the adjournment on last occasion.
J. Ginny,
J. Gini,
Associates of Mr. Jumgam Jin.
yes, Your Honor.
now is it proper to decide then in his absence?
That is what I raised the issue in the last occasion also. Whether
They appear, they are not present today,
Yes, they are not present.
maybe because of some reason. Earlier appear, if they, I thought that steps taken, but they never appeared, I thought.
Your Honor.
If they appeared earlier, then in that case, one chance can be given. Then,
Your Honor, I would request this honorable court wholeheartedly and
no, we'll
hold it
fix
hands
short
that
date, we'll fix short date, one chance will give. Not appears on behalf of the. Tabik also appeared.
one, yes, one associate junior counsel of
Jeannie, on behalf of Jeannie.
at that time, Your Honor, I think on 30th of April, if I'm not wrong, and my friend Mr. Gini was indisposed.
Indisposed, yes, yes.
Yes, Your Honor.
No, one chance can be given. Respondent number 1 is the main, okay. Okay. None appears on behalf of the respondent. So,
Imagine. Your Honor, if I may, Your Honor. Your Honor, if this IA is allowed, Your Honor, then there's always the main case, Your Honor. In the main case, they can.
Have they filed objection?
I have my
He
lord.
has filed objection.
One not,
Respondent
One has
number
not
2.
filed, Your Honor.
I am for respondent number 2.
one not
No.
filed objection.
No, not yet, my.
Your Honor, if the IA is decided in my favor, Your Honor, then respondent number 1, they can always come with the objection in the main petition also, Your Honor. So
No,
I
my lord,
request that
I cannot allow it as because
IA be decided, Your Honor.
after review also they have come as
Okay.
civil. So in the garb of an
In
appeal, civil revision petition cannot be allowed.
respondent number 1.
Already decided.
Okay, for the end of justice, respondent number 1 is given one last opportunity to appear. Please this matter on when?
It can be decided on your, it's on 25th of May. Your Honor.
25th, no more case on 25th. 28th, okay. 28th.
28.
No, can it be, it's on 1st of June, Your Honor.
1st of June, okay.
Obliged, my lord.
Item number 17.
May I please, Your Lordship?
Yes.
Lordship, may I pray that this matter may be listed on 1st of June, Lordship.
1st of June.
Conducting counsel and Pada is due to some urgent work he have to rush back.
Okay.
Otherwise, this matter was fixed today for hearing.
Okay, it is some, said that, it is submitted that Mr. N. Pada, planning counsel for the petitioner, would not appear today due to his personal difficulties, and therefore pray for listing this matter on 1st June, to which Mr. You are Modi?
Yes.
Or Modi. Planning counsel for the respondent has no objection. Prayer allowed. List this matter on 1st. Accordingly, list this matter on 1st June for hearing. Okay.
Deeply obliged.
Item number 19, it's unlisted bail matter.
The matter is not fixed. It only says that after 3 weeks.
My lord, last hearing on the 4th May, the date was given on 18 May.
Not in order sheet.
My lord, that day,
No, it is not fixed.
On the otherwise also lordship, step was not completed lordship. Step not completed lordship. Awaited service report upon lordship, respond number to the victim notice not completed lordship. As per the office note lordship.
Who is respondent number 2?
The victim lordship.
This is a POXO case.
yes, my lord, complainant.
The complainant lordship.
When he was arrested?
16 March.
Lordship, we received CD on 5th of this month, lordship. So
Earlier bail was rejected.
My lord, session court.
Rejected.
Yes, my lord.
What is the new ground you have taken?
My lord, you have to see annexure number 4. Unauthorized absent was issued by Sai.
What
24
annexure number 4?
The annexure number 4.
Where
Page
is
number
it?
16.
What
my
is the page?
Page number 16, my lord.
Yes.
Yeah. My lord, 24th, pardon me, my lord. Pardon me. My lord, 24th February को unauthorized letter issue होता है. So, my lord, issued 24 February. And she take leave from 28 February to 21 March. And I have a leave letter.
So what you are what you want to show by this?
My lord, I have some documents and other thing. This is the fake FIR. Or on the when my lord, you have to see FIR page number. My lord, page number 10. Page number 10. Paragraph number 2. My daughter, age 17, is presently undergoing training at Sai Chimpu Itanagar, 28 to 26. Psychological faculty from the academic inform me over phone. My lord,
You have a case diary.
Yes, but the lordship, we need updated CD diary, lordship.
Okay, whether the statement of the victim is there?
Yes, lordship.
Can I just see one?
Yes, lordship.
My lord, she said since molesting since November 2025. Or petitioner already a contractual employee, not a permanent. Or already Sangeeta is a permanent coach. She is living with the female player. My lord, intention behind the and my lord, assistant director of the sign, he already suspended
For what?
on the ground of the post case, molesting the female employee of the Sports Authority of India in Itanagar bench. Branch point. Internet report. And suspension order attached on annexure number 6, page number 18, my lord.
Just a minute.
Pardon me, my lord.
What is this?
The internal complaint inquiry committee report against the
Again?
Mr. Satrajit Kachari.
So why you are showing this?
My lord, because there is a procedure in sign. If anything happens, victim have to complain on that authority. Authority will inquire all this because coach will assist by has been assisted by psychologist, HPM high performance
HPM, my lord, high performance coach and a permanent female coach. Under this, under 4%, the training going on every day. If anything happens, they have submit weekly report to the Guwahati.
Okay, so you produce update.
On 16, my lord, on 7th March, victim mothers came to Mr. Umesh Kumar Yadav homes for requesting to request to remove the name from unauthorized absent letter. 7th March, and then 15 March she came with meet Mr. Kachari, and he said to Miss what is the name of mother?
Mr. J.S. Yadav.
Yes, yes, yes.
Land counsel for the applicant. Also had.
Jamuna Kachari, to said Jamuna Kachari, you have to file a complaint against him.
Mr. Loy, Lana PP, who submits that since the case was not fixed today, he could not produce the updated case diary and prays for some more days, or some time to produce the updated CD stuff. The record, the office note dated 18, office note also reflect that the notice upon the respondent number 2 is still awaited. In view of the above, list this matter after. The notice, have you taken? Not yet received. Okay. Let the respondent number 2 also appear. List the matter after 2 weeks.
My lord, much more time because Asian Games trial already going on in Japan, or trial already in last week of
See, the students, if cause trouble, then nobody will be able to join.
My
None of
lord,
the lady
already
will be able to
seven student was taken from the Itanagar.
No idea. But then we need to protect the students
Right.
who
I
are
understand.
more in numbers. The coach is only one, but then the students are more in numbers.
Yeah, yes.
If the coach start troubling the student, it becomes very difficult.
My lord, I have relieving order every month from